they'll give a counter opinion. As I said, the moment you give a counter opinion, it will be only debate. Either you accept, it's non-binding opinion. Either you accept or don't accept. But this is my view, sir, because then it will not be my personal. Same thing like JSS, we will not have our own opinion. We are persuaded by someone else's view.
Correct.
So then they stop that thing. Counter.
In Chennai, it has to come to settlement commission. Lots of settlement offices.
That stand is always the best.
About it, what the inspector or superintendent would have made a note. The best facts available is with them.
When they pass the assessment orders, they are the real artists.
Yes, yes.
Because we only have this on that sort of, wasn't that the real? Brief discussion about that. So the facts are such that the company matters before the Supreme Court. So we have a reversal finding by the Karnataka Court. So we will just allow the reversal petition. So the appellant is actually the taxpayer who does input of the business, and they have certain exports. When those customers actually do not make the payments promptly, so that is one issue regarding, because we know that whenever any exports are being made, we have various benefits, both income tax as well as GST. All the ITCs up to the penultimate sale will be entitled for a refund. So that is one aspect of it. Other one is with regard to various supplies that they have received from their domestic suppliers. The appellant purchases various materials, and technically, as we know, there are certain forms which we are mentioning about. If the sale is made to a particular person, this is the amount of sale, and this is the ITC that the person is entitled. So that will be mentioned in 2A. As a purchaser, I will also be filing my monthly returns. One such return is Form 3B, in which I will be telling what are the invoices raised on me, and what ITCs I am entitled, and what are the outward supplies, and I will be offsetting net tax liability. I will mention. The department says we will not be providing. So the department's view is that unless the person actually pays it, I will not be able to collect the taxes that has been received from you. And it is their stand that it is only whatever you actually claim, the invoice amount or whatever ITC, it's only a provisional basis. Unless it is actually deposited to the government's account, you will not be able to. But the problem with the buyer is that if I am a genuine buyer, I would have paid top of the invoice, I would have paid the GST. And I have to once again pay the ITC, I have to pay the interest also. Some cases there is also penalty rate. So this is something which is a huge cash flow issues with the suppliers. So now this appellant faces both the issues. He made certain exports, but almost during that financial of the overall exports that they made on the turnover value, 10% of it they were not able to realize in foreign exchange. So that is one of the conditions in GST as an exporter that will be denied to you. Now in this case, what the stand that they take is that the department issues a notice. Now one other issue is that this is pertaining to financial year 18-19, but the show cause notice.
Greetings to the bench. This is the counsel on behalf of the appellant in the instant case of SSIL Bangalore versus Ministry of Finance and another. The counsel recognizes the presence of a ladyship and would humbly seek permission to collectively refer to the bench as your lordships. Much obliged, your lordship. Today, we are here for justice, where a government department has strong-armed an honest and hard-working company by denying them their rights and bending the law that they have sworn to protect. I would like to seek permission to submit facts of the case. Much obliged, your lordship. The appellant is a GST registered software company regularly exporting and availing ITC and export refunds while maintaining proper statutory compliance. In financial year 18-19, export proceeds from certain foreign buyers were not realized in times and ITC mismatches arose due to suppliers' failure, even though there was payment on part of the appellant. The respondent issued notice and passed order denying ITC and direct recovery of export incentives. After the adverse decision by the division bench of the Honorable Karnataka High Court, the appellant has preferred the present petition before your lordships. If your lordship is satisfied, the counsel seeks permission to begin with the arguments. Much obliged, your lordship. The counsel will be dealing with the first two issues, of which the first issue is whether Notification 56/2023 is ultra vires of Section 168A of the GST Act 2017. Your lordship, the counsel will be dealing with the first issue in a three-pronged manner, of which the first prong is that the notification issued violates the mandatory procedural requirement prescribed by Section 168A of the Act. Your lordship, it is most humbly submitted that the Notification 56/2023, which extended the time limit for passing the impugned order, was issued by the government on 28 December 2023 and was thereafter ratified by the council. The requirement for recommendation by the GST Council under Section 168A is the mandate of the Parliament as given in Tata Play Limited versus Union of India 2025. Your lordship, under such a mandate, the condition of recommend becomes a sine qua non, that is, a necessary condition without which the union and the state cannot exercise their power. As stated in Barkat Ki Print Media Services versus Union of India 2024. Your lordship, therefore, the notification not being a recommendation of the GST Council is ultra vires of Section 168A of the Act. Even though there was a post facto ratification, that does not comply with statutory requirement, your lordships. If your lordship may be kind enough to turn to page 56 of the compendium. Is your lordship with me?
This one, is it?
No, your lordship, it's the one that, the other one, your lordship.
Page?
Page 57, your lordship.
I don't have the appellants.
Your lordship, the council has provided for 3 compendiums for the bench.
Yes.
Okay. Your lordship, the first para, last line reads that it is submitted that since the language of Section 168A is unambiguous, that effect has to be taken. The effect being that the impugned notification 56 is an ultra vires to the Parent Act. Your lordship, the language is unambiguous in...
Where are you reading?
Your lordship, the first para.
Page?
Page 56, your lordship, of the compendium. So, apologies, your lordship, page 57.
57, is it? That is the Telangana High Court.
Indeed, your lordship.
Huh? Telangana High Court.
Indeed, your lordship.
What paragraph?
Page 57, the first para.
Is it above para 36?
Indeed, your lordship, above para 36.
Ah.
The impugned notification number 9 and notification 56, that is the notification that is pertinent to the case, is ultra vires to the Parent Act. And the last line, it is submitted that since the language of Section 168A of the GST Act is unambiguous, it has to be given effect to. Your lordship, the line on the recommendation is unambiguous, making it a statutory requirement for the department to be followed, which was not followed.
So shall we read, why don't you read the section and then it is unambiguous. That's what has been submitted before the Telangana High Court.
Indeed.
You read the section and say how it is unambiguous. Let's see whether the section is ambiguous, unambiguous.
Indeed, Your Lordship. I will read the section for Your Lordship's convenience. Notwithstanding anything contained in this Act, the government may, on the recommendation of the Council, by notification extend the time limit specified in or prescribed or notified under this Act in the respect of the actions that cannot be completed or complied with due to force majeure conditions. It clearly reads on the recommendation of the GST Council, which is absent in this case, Your Lordship. And even if there was a post facto ratification, prior recommendation does not equal to post facto ratification. As
Why it uses the word the government may.
Indeed, Your Lordship.
What's your argument on that? It's not government shall.
Your Lordship, in Tata Play Limited versus Union of India, the Honorable High Court.
Don't refer to the judgments. Give us your view on the provision. We want you to know your view, not the court's view.
Indeed, Your Lordship. Even if it reads may, the Lordship, it is followed by on the recommendation. Your Lordship, on means in respect of or reliant on the basis of. The Council may or may not hold the recommendation, but it is a necessary condition that once the recommendation is given, then only a notification can be issued by the department. Is Your Lordship satisfied?
No, I would say, I mean, that perhaps is not the correct way of reading the provision. You have to read the commas in between.
Indeed.
The government may, on the recommendation of the council, comma, by notification extend. So your argument should be that the government may extend the time, not may on the recommendation of the
Indeed, Your Lordship, there might be some misconstrued, but what the council means to say is that it is not directed to the government to issue the notification or not. That is on the whims of the government. But when the government issues the notice, it has to be on the recommendation of the council. Is Your Lordship satisfied?
Yeah, so on the recommendation, why should it be before the extension? It can be post facto also. Why not? It's only a recommendation.
The council takes cognizance of Your Lordship's concern. Your Lordship, it mentions first on the recommendation. The word here on means on the basis of. On the recommendation, then after it comes the issuance of the notification. Here, recommendation before the issuance of order is a necessary procedural requirement, and therefore it has to be prior. Indeed, Your Lordship.
279A of the Constitution.
Indeed, Your Lordship.
Can the GST Council delegate its power to GST Implementation Committee?
No, Your Lordship. The GST Council's recommendation has to be necessary in this because, Your Lordship, the Council is formed with union and the state in mind. The idea with which the Act was conceived was to create a collaborative federalism in harmony, where the GST Council creates a uniform taxation system, keeping in mind the interest of state and the legislature and all the relevant stakeholder, that is the honest taxpayer of the country. Your Lordship, when the government unilaterally passes this notification, when they completely undermine the wishes of the states and the GST Council, therefore that is in contravention to what the initial idea of the legislature was, Your Lordship. If Your Lordship is satisfied, I may seek permission to continue my submissions.
Can you read subsection of 168?
Indeed, Your Lordship. I may read it for Your Lordship's convenience. The power to issue the notification.
Can you speak little away from the mic, please? Little away from the mic.
Indeed, Your Lordship.
Keep the mic a little away because there's a resound of we can't hear you properly.
The power to issue the notification under subsection 1 shall include the power to give retrospective effect to such notification from the date not earlier than the date of the commencement of this act.
To some extent, retrospectivity or ratification is permitted.
Your Lordship, this is in regards to the power of the notification. That the notification goes back in time and then it is a remedy for him. For in this case, that the notification then allows for the extension of time. It is not relevant about the recommendation of the GST Council. If Your Lordship may please refer to the minutes of the meeting of 49th GST in the compendium. Page 65, Your Lordship. Of the compendium, Your Lordship.
That is regarding extension of
Indeed, Your Lordship.
COVID-19.
Indeed, Your Lordship. I may read it for Your Lordship's convenience.
Please.
The minutes of the meetings, last 3 lines say, it was discussed in detail in officers' meeting where one view that the extension of had already been given of financial year 17-18 and the further extension may create a perception that it is not a tax-friendly measure and against the interest of the taxpayers. Your Lordship, the Council in itself was aware that this notification or further extension is burdensome on the taxpayer and it is not a tax-friendly measure, and still disviewing, not taking in view of this view of the GST Council, the department went on to give the notification.
No, this is the second extension. This is not that extension was given much prior. They asked for a second extension and that's what the council refused.
Indeed, Your Lordship, there were multiple extensions given like notification 9, notification 56. Multiple extension, what is being said, the view that was held in the meeting was multiple extension is being burdensome to the taxpayer.
Correct, it may be. So therefore the second extension is burdensome. The council didn't feel that the first extension was burdensome. Council ratified the first extension.
Your Lordship, it only ratified after the notification
Correct.
was
So
passed.
that's the point. So refusal of a second extension cannot be taken as, the GST Council's, views on the first extension. That's what I'm bringing.
Indeed, Your Lordship, but the prior recommendation, first the recommendation, then passing of the notification is a necessary requirement.
No, where does that read in the section? The section doesn't say so.
It's, Your Lordship, the section reads on the recommendation of the GST Council. The notification can be issued.
So that's what you have to say. You have to say that your argument is that on the recommendation has to be there prior to the issuance of the notification.
Indeed, Your Lordship.
Because of the use of the words on the recommendation.
Indeed, Your Lordship.
All right.
If Your Lordship is satisfied, I may seek permission to move on to my next argument. Your Lordship, the next...
Also, just to be clear on one other aspect,
Indeed, Your Lordship.
provision reads that notwithstanding anything contained in this act, the government may. Now, if we were to interpret the word may, which is not used as shall, now can we say that the whole procedure that is prescribed under the section 168 is only directory in nature rather than mandatory?
The Council
Because
takes...
just to add to that, the whole event of issuing this notification itself arose because of admittedly a force majeure. Right? But for that force majeure, this notification would not have been issued at all.
Indeed, Your
So
Lordship.
if we were to give a purposeful interpretation of this particular provision, given the special circumstance,
Indeed.
if we say that it was only a may,
Indeed, Your
the
Lordship.
government may act upon the recommendations. So it may first issue the notification because it is not mandatory, and subsequently it has placed it before the very same council for its ratification. So if we see in that perspective, will it not survive?
Very valid concern of Your Lordship. Your Lordship, the force majeure argument, I'll be dealing with my submissions. On the word may indicates that it may give a notification when there is a force majeure condition for the extension. It is regarding the notifications of the extension. The word is not relating to the recommendation. It says that it may on the recommendation. It may issue the notification, it may or may not, but when it issues the necessary notification, it has to be on the recommendation of the council. Is Your Lordship satisfied? Much obliged, Your Lordship. The second argument is that the force majeure circumstances did not exist on 28/12/2023, on which the notification was passed. Your Lordship, Section 168A, Clause 1 explicitly mentions that the notification can be passed in respect of the actions that cannot be concluded due to the force majeure conditions. The force majeure conditions that had been labeled in the section are in case of war, epidemic, flood, fire, drought, cyclone, and any other calamity caused by nature. The day on which the impugned notification was passed, the claimed force majeure, which is the pandemic, had subsided, as given in page 83 of the compendium, the report of PwC, Your Lordship. Your Lordship may also refer to the last page, page 97 of the compendium, which is a report of the Ministry of Health and Welfare. It says, dated 30th January 2023. Your Lordship, it says that the active cases stand on 0.01%. The total vaccination doses were 220.45 crores. Your Lordship, most of the restrictions had already been lifted. Almost all of the country had already been immunized. And even after that, the department is claiming that there was a force majeure condition.
No, Council, this one, we cannot stand here to decide as to what is the amount of workload that called accumulated over the period of time. There cannot be a statistical way to prove that on the date of the notification there was complete subsidization of the COVID pandemic. Right? There was so many accumulation of the work because the whole country suffered. So we cannot be stepping into the shoes of the department to say as to when they should be ready to fully work, right?
Indeed, Your Lordship.
Yeah, there were lots of network issues and so many problems the department had. So that cannot be taken.
A very valid concern by my ladyship. I may please request you to turn to page 72 and 73 of the compendium. 72, Your Lordship.
Yes.
Your Lordship, under the 49 GSTA meeting, first point, it says, while COVID-19 initially met the criteria of force majeure, Your Lordship, initially, the subsequent notification, particularly those after 2021, failed to justify how the pandemic continued to hinder departmental functioning. And by 2023, most of the restrictions has been lifted and doubts on the necessity of further extensions. Your Lordship, the second para reads that the notification 9 for issuing the order under section 73, clause 9 for financial year 18-19 seems to protect departmental inefficiencies over extended period. If Your Lordship may read the...
What is this that you are reading?
Your Lordship, this is a journal.
Why are you reading from a journal?
Your Lordship, this is a journal by a professor and a research scholar detailing the unnecessary issuance of the notification 56.
No, that's his opinion. What is your argument on that?
Your Lordship, it concludes the whole paradigm that was there, that even though there was a pandemic in 2020, 2021, but by the time the notification was issued, that is 28/12/2023, COVID-19 had already subsided. The machinery, the administrative economic machinery of the country had already started working. The department had already been working for a very long time, and still, after all of this, the department still claims that they were troubled by the force majeure conditions, Your Lordship.
No, this was already discussed, no? There were so many issues for the department. So the main manpower didn't work for a long time and network issues were there. So this cannot be taken.
Very valid concern of Your Ladyship. Your Ladyship, there has to be a reasonable limit to till when can the department claim.
What is that reasonable limit?
Your Lordship, but for there to be a reasonability.
No, the department knows, na? What is the limit? Reasonable limit is defined by the
Your Lordship, department
Ministry of Finance. Huh?
Indeed, Your Lordship, the department cannot claim that we can't perform this work. Henceforth, we are claiming that there was a force majeure condition because of which we are doing. The department is accountable to the taxpayers.
When they had other problems like filing of returns, they wanted a extension. All that was given.
Indeed, Your
So
Lordship.
why don't you think in that line?
Your Lordship, as the 49th GST meeting, minutes of the meeting read, that even the GST Council accepted. Your Lordship, the paucity of time, I would humbly request your generous lordship for extension.
Yeah, but are you arguing on the issue number 2 also?
Indeed, your lordship.
But the issue number 1 and 2 are the same, isn't it? What's the different argument for issue number 2? Your issue number 2 is on the extension of limitation.
Indeed, your lordship. I will argue issue number 2
So
regarding.
you are arguing both the issues together.
Indeed, your lordship. Your lordship, as I was saying, the GST Council was already aware that further extensions were not required, as it was not tax friendly, and it made to look that the department is hiding its deficiencies, your lordship.
Council, one.
Indeed, your lordship.
The pending work due to pandemic was only due to the non-functioning of the department or non-availability of opportunity to taxpayer.
Your lordship, the appellant had been working and had filed the correct documents and returns.
Pandemic, if officer was working,
Indeed.
notice would have been issued. So what would have been the taxpayer's response
Your
during
lordship,
pandemic?
your lordship, the council is not.
Had a notice been issued by the department, because if you want the department to be so prompt that they should alone be immune from the COVID pandemic, if a notice would have been issued during the pandemic to you as an SSC, if this notice was issued to you during the peak of the pandemic, how you would have reacted?
Indeed, your lordship, if the notification was issued and followed proper procedural requirements.
No, not on the lordship is
Notice,
asking.
notice,
The
show cause
notice, the show cause notice was issued later, right? When was the show cause notice issued in this case?
Your lordship, 31/2024.
Had it been 2 years prior to that, let's say it was on 31/2022, how you would have reacted?
Your lordship, if the show cause notice and the notification was issued on a prior date during the pandemic and prior to the pandemic, with all the procedure requirements, it have been a completely different scenario.
Yes,
but
that's
in the
exactly.
current scenario, lordship, it was not notified on time. There were no relevant force majeure conditions. The department had plenty of time, and the GST Council accepted that there was no need of further extensions because it only made the department look bad on its part.
We would like to know what prevented you from responding to the intimation issued to you on 7th of September 2023.
Indeed, your lordship, the intimation was given on 7/9/2023 by way of an email. Your lordship, the intimation or non-answering of the intimation does not create a bar on part of the appellant. Your lordship, the idea of the intimation was to answer all the questions or doubts of the department, which were later answered when the show cause notice was issued. The department the appellant clearly issued all the necessary documents, showed all the banking channels, the transactions, and satisfied the department with all the questions. Is your lordship satisfied? Due to paucity of time, I would like to sum up the issue 2, which is regarding the extension of limitation, and if the limitation hence is said to be set aside. Your lordship, the extension of limitation is arbitrary and lacks legal justification. For an order to be reasonable, it has to pass the reasonability test of R.K. Garg versus Union of India, the landmark judgment on arbitrariness. It has 2 prongs. First, there has to be an intelligible differentia for the necessary order. Second, there has to be a reasonable nexus with which the order is issued.
Counsel, what is your view on the Tata play?
Indeed, your lordship.
Though it is only persuasive on us, it appears that the learned single judge of the Madras High Court has held that by applying this honorable court's extension of limitation, so that limitation got renewed as of 1/3/2022, and thereafter they have 3 years time. So if you were to apply that logic, the notice would still survive.
Your lordship, please.
Are you aware of the Tata play judgment?
Indeed, your
What
lordship.
does it say?
Your lordship, the Tata, there are multiple.
On the notification aspect, what does it say?
I may read it for your lordship. It is on page 94 of the compendium.
We should be able to tell it offhand. Now we understand that in that case, even if the notification is not applied, still the department's notice issued would survive, because the Supreme Court, this court itself, had extended the limitation up to 28/2/2022. The whole of Limitation Act, or the whole of limitation across all statutes were in suspension.
Indeed.
So if thereafter the limitation started again, so if that logic is to be applied, then this notice was issued as well within the limitation period.
A very valid concern for your Lordship. The Lordship is supplemented with the circular by the Central Board of Indirect Taxes and Customs, Circular 153 dated 20th July 2021. If your Lordship may refer to page 2 of the circular, last para, your Lordship, 3 subclause 6. It reads that as regarding the issuance of the show cause notice granting time for replies and passing orders, the present orders of the Honorable Supreme Court may not cover them even though they are quasi-judicial proceedings, as the same has only been applicable to the matters relating to petitions, application or suits. Your Lordship, this circular clarifies that the extension of limitation by Honorable Lordship does not apply to this case because it is neither a petition nor a suit nor an application.
So we are in a situation where this Honorable Court extended the limitation. There comes a circular saying that we don't want to enjoy the benefit of the judgment of this court. Is it not the consequence of this circular? This circular says we are not bound by the extension of this court, right? But this circular says that we don't want to follow that. Will that hold good?
Your Lordship, the circular clarifies and puts us in a position where it does not apply on us.
Yes, if it doesn't apply to them, the department, if you were to interpret it saying that this circular is dehors or beyond the scope of the judgment of this court, then if your argument is entirely reliant on this particular paragraph, which says that we don't want to be bound by the extension given by this court, that's what you tried to say, right?
I would humbly apologize if that may seem in this case. Your Lordship, we are not beyond the judgment of your Lordship. The judgment in itself clarified that the limitation will only apply in cases of judicial and quasi-judicial proceedings in case of a petition, a suit, and an application.
Is it not a quasi-judicial proceeding appearing before the assessing officer under section 73?
Your Lordship, but it clearly reads that the issuance of a show cause notice or granting time for replies or a passing order is not covered.
That is a circular, right?
Indeed.
No, that's what. If this court had intended to give the benefit across all the limitation, can a circular curtail it?
Your Lordship, but the proceedings of the department are bound by this circular.
Fine.
Indeed, Your Lordship. Your Lordship, just 30 seconds to sum up my argument. As the counsel was pleading about the arbitrariness, the first prong that there is no reasonable, intelligible differentia, that as argued before, the COVID-19 pandemic had already subsided and the department, the administrative functioning was well in its functioning. It's well beyond its functioning. And in the second prong about the reasonable nexus, Your Lordship, as Your Lordship had pointed out, the idea with which this Act, GST, was concepted was to create a uniform taxation system in collaborative harmony and federalism, with the idea that the union and the state can mesh together and create a reasonable taxation system. When the GST Council completely disregards when the department completely disregards GST Council's recommendation, does not take into play what the state legislature has to say, and then later ratifies it and creates a unilateral decision, it completely stamps on the very reason why this legislation was conceived, Your Lordship. If Your Lordship are satisfied, I would like to invite my co-counsel. He will be dealing with issue 2 and issue 3.
Get the permission, counsel. Yes.
Much obliged, Your Lordship. It was an honor pleading before you.
The counsel seeks 10 seconds to read the documents. Greetings to the Honorable Bench. This is the second counsel on behalf of the appellant in the instant matter of SSIL versus Ministry of Finance and another. And I shall be dealing with issue number 3. Is the counsel audible to you, Lordship? And I shall be dealing with issue number 3 and 4. If your Lordships are well versed with the facts of the case, the counsel would like to directly proceed to issue. Much obliged. In it is humbly submitted before the Honorable Court that the non-repatriation of foreign exchange within the stipulated time on exports made by the company would not result in denial of such export incentives. The Council shall be making a two-pronged argument under this issue. First, absence of any statutory mandate under the IGST framework for zero-rated supplies. Your Lordships, it is important to note that nowhere does the IGST framework mentions and links the benefit of zero-rated supplies to the repatriation of foreign exchange, Your Lordships. It was only further added by 96B and proviso to section 16.3, which was only introduced in 2020 and 16.3 with effect from 2023. Since your Lordships are aware, the present proceedings deal with financial year 2018-19, the same shall not be applicable to the present case, your Lordships. Furthermore, your Lordships, it is important to note the very nature of the zero-rated supplies, your Lordships. Section 16, as per the compendium, page 28 of the compendium, mentions that the essence of the zero-rated supplies are to ensure that the companies are not made to pay tax on the exports that they make. Your Lordships, as you're aware, that GST is a destination-based tax and not a source-based tax. Therefore, my Lords, India does not have a jurisdiction to tax or export. Export reads to the other countries on their jurisdiction. My Lords, every country has systematic duties to charge on the exports. My Lords. Therefore, your Lordship, the very purpose of the zero-rated supplies is to ensure that companies freely engage with transactions and sales of exports and goods and services. Therefore, your Lordship, the very idea of not giving the refund to the company goes against the principle of the zero-rated supplies, your Lordships. If your Lordships are satisfied and do not have any question on this.
The issue is not taxing on the exports. And you are referencing that they do not have jurisdiction. For more than one reason, we will not be taxing exports to be competitive with the global market. But the department seeks the refund of all the benefits that we enjoyed after the penultimate sale.
Indeed, your Lordship, the SSIL has already obtained the refunds as of 31st December 2019. Your Lordship, the very purpose, the very reason why appellant today has approached the Honorable Court is to argue that the departmental or the Honorable High Court's judgment, which allowed the department to extract the already obtained refund of the export incentives. If that answers your question.
Bound to refund, right?
Yes,
but to the extent you are not able to repatriate the foreign currency. The law is clear. What is your difficulty in returning the refunds of payment?
Your Lordship, since the Council has already stated that the GST framework does not link the benefit of claiming a zero-rated benefit from the repatriation of foreign exchange. Repatriation of foreign exchange as a condition is only mentioned in the FEMA provisions, and the Council shall be addressing the FEMA provisions.
You are claiming benefit out of export of service. Please read section 6 to section 2, section 6, definition of export services.
Your Lordship.
Please read the export of service.
Your Lordship.
The IGST.
Your Lordship, that provides for convertible foreign exchange which should be brought back. Your Lordship. 10 seconds, Charles. Your Lordships, Section 264 states that, quote unquote, the payment for such service has been received by the supplier of service in convertible foreign exchange or in Indian rupees wherever permitted by the Reserve Bank of India. In this case, you have not received. Your Lordships, it is humbly submitted before the Honorable Bench that we could not able to realize less than...
The reason for non-receipt is okay, that's understandable, but you don't even satisfy the definition of export of service, so there is a question of refund. It doesn't amount to a zero-rated supply at all.
Clause 1 to 5 is a cumulative compliance.
The answer.
1 to 5 is a cumulative compliance. 1 to 5 in subsection 6 is a cumulative compliance. So So if any of the condition is not satisfied, it will not fit in the framework of export of services.
And once it is
Don't ignore and between 4 and 5. There is a purpose.
The council takes notice of the same, Manoj, and that's a very valid concern. To answer your lordship's concern, the council would like to state that it does not mean that the entire foreign exchange should be repatriated to India. And your lordships, the parliament is cognizant of the facts. For all practical purposes, your lordships, in the commercial world, there are certain practical scenarios where we as companies are not able to repatriate the full foreign exchange. In the present case,
We have any circular issued by the RBI, or is there any legal vacuum?
your lordship, since I've addressed the first part, I'll come to the second part, FEMA compliance.
To answer this particular point,
Manoj,
the argument that there is no, based on logic, that there is no necessity to keep the entire exports.
your
Do you have
lordships,
any legal?
Your Lordships, that brings me to section 8 of the FEMA Act. If you may kindly refer to section 8 of the FEMA Act. Ten seconds. Your Lordships, Section 8 of the FEMA Act reads, save as otherwise provided in this Act, where any amount of foreign exchange is due or has accrued to any person resident in India, such person shall take all reasonable steps to realize and repatriate to India such foreign exchange within such period and in such manner may be specified by the Reserve Bank of India. Manoj, the humble submissions of the council is that GST framework does not explicitly mention the repatriation. The condition, and Manoj, since the very fact that we have obtained the refunds on such issues, that would only be done if the department recognizes the transaction and the supply as exports of services.
You mean to say that the provision of an analytical provision should be existing in the GST Act?
Manoj,
Saying that for the purpose of fulfilling, if there is a connect, if there is a reference with regard to when they say such prescribed manner, it takes us to another statute, right?
Indeed,
But for all purposes with regard to foreign exchange, RBI and FEMA is the regulating act.
Indeed,
So
Manoj.
when the condition is prescribed there, the GST Act is, there is a connect between the GST Act and FEMA, the provision which you read now.
Manoj, now to answer your Lordship's concern, that's a very valid concern. Your Lordships, we should refer to the legislative intent of the wording of the section 8. Shall take all reasonable steps to realize and repatriate. The Parliament is aware of the facts. It is not mentioned shall repatriate the entire. It is not mentioned shall realize and repatriate. It is mentioned shall take all reasonable steps.
Which section is that?
Section 8, your Lordships, of the FEMA Act.
Of the FEMA Act.
Of the FEMA Act.
Now, why are you bringing the FEMA Act into the GST?
Your Lordships, since
How is FEMA, the provisions of FEMA apply when you are interpreting something under the GST?
Since it is a case of export of services and realization of and repatriation of foreign exchange is dealt by Enforcement Directorate and the Foreign Exchange Management Act of 1999 deals with the rules and provisions of repatriation of the foreign exchange. Therefore, Manoj, FEMA is attracted in the present proceedings.
No, but GST Act can say, GST has defined what is export of service.
Yes.
Now the Act can say, if you satisfy this, only then it's an export of service. There are conditions under section 2, subsection 6, correct? There are 4 or 5 conditions. If any one of the conditions are not satisfied, the Act says it's not an export of service. So there is a motion of refund of
Manoj, to answer both your Lordship's concern, your Lordships, the very fact that SSIL obtained refund as of 31st December 2019 for the financial year 18-19, it makes it very obvious the department was aware of the nature of the transaction.
No, then because of that will come later. We cannot say that there will be simultaneously they will be watching regard to the exports made by. But that cannot be the argument. What we are trying to understand is that when the GST Act defines what is export of service, you will have to convince us that you have fulfilled all the requirements. And specifically the bench points out a lacuna. Bringing in foreign currency into the country completes the export of service. And that has not happened to the extent of 10%. To that extent, there is no export of service.
A very valid concern, Your Lordships. However, the very fact that less than 10% of the foreign exchange could not be brought back, and that condition is precisely led by master direction of the RBI 2015-16.
Imagine the tax effect is 1,000 crores. 10% is how much?
100 crores.
100 crores. Can the department forego just because it is less than 10%, it is 9% or 8%? Can they forego 100 crores?
Your Lordships, the RBI direction 2015-16 itself consider these practical, if you may kindly refer to page 45 of the comparative. Given the practicalities of the commercial world, Your Lordships, since the certain directions have already been issued, because it is a very reasonable and anticipated measure that full foreign exchange could not be repatriated, which is the case with us. Less than 10% could not be repatriated, Your Lordships. Your Lordships, it mentions write-off of export bills, my lords, and
Where?
43, page 43. Write-off of unrealized export bills. C23. It mentions write-off of unrealized export bills. So to answer Your Lordship's concern, that can indeed be done, Your Lordships.
Can you read that?
That is for the purpose of income tax, if at all, treat it as a bad debt or whatever.
Your Lordships, it is important
Who has to write off first? Who has to take us to this particular thing? We are not able to follow you.
My lords,
When you say write off of unrealized, who should write off?
my lords, there are three conditions as to write-off, my lords, as the council shall explain. First, self-write-off by an exporter. Second, Your Lordships, self-write-off by a status holder exporters. And third, Your Lordships, write-off by an authorized dealer. Therefore, Your Lordship's concern, in some situations, indeed write-off can be provided.
Who is
And,
an authorized?
Your Lordship's authorized dealer, bank one category are the banks that are notified by the RBI who are supposed to convert the amount that is realized into the INR.
They are the extension of the RBI. Right?
Well,
They are the extensions of the RBI. Did they write off this extent in your case?
My lords, the Moot proposition is silent about this issue, and in absence of any fact, it would be wrong to assume, since my lords, there has been no proceedings under FEMA. Had such write-off not been asked for, there certainly would have been certain proceedings under Enforcement Directorate. Since Moot proposition is silent about this fact, it would be wrong to assume that it has not been done.
So two wrongs make a right. ED has not come behind you. Therefore, can you say the GST department cannot come behind you?
My lords, since now I shall refer to the FAM Act, it mentions take all the reasonable steps. If Your Lordships want the council to explain how the condition of all reasonable steps are
Now, by introducing FEMA provisions, then you rewrite subsection 6, definition of export of service.
Can Your Lordships please repeat your concern?
By reading FEMA provisions into export of service, subsection 6, can you rewrite? Will it not amount to rewrite? You are claiming somewhat exemption under section 16, subsection 16, claiming refund of input tax, subject to compliance of, subject to if it is export of service. Export of service defines 5 requirements. One of the requirements is you should receive the consideration, export consideration, convertible foreign exchange. So, what is the significance of this convertible foreign exchange there? The FEMA may deal with that. The FEMA may give ultimately exempt you from, even if you don't bring foreign exchange into country. But whether you are entitled for zero rated supply and refund of your import has to be strictly in compliance with that. And the Supreme Court judgment, you must be aware, the exemption condition should be strictly applied.
A very valid concern, Your Lordships. To answer Your Lordship's concern, the Council would like to humbly submit that in the present, that the condition does not mention shall repatriate the entire amount. And since my lords, with respect to your previous concern as to how FEMA comes into picture, Your Lordship, since the very nature of exports is involved on the supply of services, therefore, my lords, both the FEMA and IGST should be read in complementary.
No, non-repatriation of foreign exchange within 1 year. Will it not trigger tax liability as per Rule 96 capital A sub Rule 1?
Indeed, Your Lordships, that's a valid concern. However, since it does not mandate the full realization, the full repatriation, and since FEMA, the very act dealing with the realization, is cognizant of the fact that what is required as well as statutory obligation upon SSI is to take reasonable steps. And now coming back to IGST, Your Lordships. IGST does require convertible foreign exchange to be brought back, which will also be tried in the best of our capacity, undertaking all the reasonable steps and could not break more than 90.
What reasonable steps will be taken?
Well, since Your Lordships have raised the question of reasonable steps, the Council would like to state that first, we undertook follow-ups and sent emails to the foreign buyers. If Your Lordships may kindly refer to para 5 of the Moot proposition, which is also the para.
Will that suffice sending an email? Will that suffice sending an email to your foreign buyer to pay back for clearly invoice? Can that be treated as a reasonable step?
Your Lordships, if you may kindly refer to page number 44 of the compendium, the RBI direction.
No, but the reasonable steps may be a consideration for the purpose of FEMA or for the purpose of writing it off as a bad debt or whatever. Can reasonable step be a consideration for the purpose of GST?
RBI is only a regulatory body.
Can
Can the RBI regulations override the parliamentary enactment?
No, Your Lordships. However, in absence of proper definition of what reasonable means, we have to understand this with respect of the circulars, the directions, and the notifications that have been issued. And RBI direction, Your Lordships, you may refer to page 44, mentions the case falls under any of the undernote categories. These are the reasonable categories which RBI believes are. Since IGST Act does not clearly provide for the A to XYZ reasonable categories, it's only circumstantial and conditional. And
Since it is export of services, not goods, you need RBI permission in this case?
indeed, Your Lordships, if Your Lordships may kindly refer to B, the overseas buyer is not traceable over a reasonably long period of time, which was the case, Your Lordships. We sent emails, communication to them, which went unanswered. As per 3B of RBI direction, it is a valid and a reasonable step. Now, my lords, if you are not satisfied, the SSIL even went a step ahead. Again, approached the Indian consulates and embassies, but still could not be successful in repatriating the foreign exchange. And this also, Your Lordships, in point number D of the RBI, quote unquote, the unrealized amount represents the balance due in a case settled through the intervention of the Indian embassy. The RBI itself recognizes this as a reasonable step. Third, my lords, commercial prudence in avoiding litigation. Your Lordships, in the commercial world, it is important to highlight that had SSI initiated a case in foreign country, that would have not resulted in a reasonable benefit to us. The cost of the litigation, my lords, in a foreign country is extremely high, as your Lordships are aware.
So you assume that you will lose.
My lords, the point number F clearly mentions RBI itself allows in that situation. Quote unquote, the cost of resorting to legal action would be disproportionate. The
How do
RBI,
you assume that the cost would be disproportionate? And even successful, you have also got the cost of the litigation. Did you issue at least a legal notice?
Your Lordships, as per the Moot proposition, if you may kindly refer to para 5 of the proposition, Your Lordships.
To just conclude on this issue, you have hardly any kind of other.
The para 5, Your Lordships, to answer your concern,
Can move on to the next issue.
just 10 seconds, my lords. The SSIL undertook all the reasonable steps, emails, contacted them, but they were not traceable, my lords. Therefore, due to third-party default, we should not be held liable and our refunds be taken back. And second, Indian consulates, and third,
Next issue.
my lords. If Your Lordships,
Before going to one,
Your Lordships.
you made up all reasonable grounds and excuses for the bona fide reasons. So you are not arguing the constitutional validity of definition of export of services. You are answering the show cause notice.
But
So where is the power vested with the proper officer to accept all your arguments?
Your Lordship.
Where is that such power conferred on the officer?
Your Lordships, that's a very valid concern. However, since the Council previously mentioned, the FEMA provisions and IGST provisions work in consonance and harmony with each other. And therefore, Your Lordships, RBI directions and certain other provisions shall be read to be the reasonable steps. Now proceeding to issue 4, Your Lordships, it is humbly submitted before the Honourable Court that the non-mentioning of GSTR 2A on the supplies made by the supplier in its GSTR 2A would not deny such ITC in the hands of the purchaser. Your Lordships, the Council advances a two-pronged argument. First, I deal with GSTR 2A and then the conditions under section 16 to Your Lordships. Firstly, it is humbly submitted before the Honourable Court that GSTR 2A is a read-only statement or auto-generated statement. Your Lordships, if your generous Lordships are much obliged with us. Perhaps GSTR 2A is an auto-populated statement. GST plus GSTR 1 is the form wherein the suppliers put the invoices, and GSTR 2A is the automated form that is made from GSTR 1, and GSTR 3 is a form wherein the supplier puts the invoices and claims the ITC. Therefore, the non-mentioning of the invoices by the supplier, the third party default cannot be construed in a manner so as to deny our rightful claim to ITC or not.
No, section 16, subsection 2 clause C clearly says that it is a statutory condition that government should get revenue. In your case, it is not mentioning the invoice. The supplier has not paid the government at all, having not received the money. How can they refund you the ITC?
Since the Council said they would address the first issue, I'll summarize in first minute the GSTR issue and then come to the section 16 issue. If the Lordships are fine.
Please.
Much obliged. With respect to GSTR 2A, it is important to understand that before 2022, the concept of provisional ITC was in place. So provisional ITC provided for self-assessment. Self-assessment as in GSTR 2A was set to compare to GSTR 3B and should be checked. And in case of mismatch, the department checked whether the transaction was valid or not. Now, Your Lordships, if you may kindly refer to the press release of the CBIC of 18th October 2018, it clearly clarified that form GSTR 2A by the recipients is in the nature of taxpayer facilitation and does not impact the entitlement of taxpayer to avail ITC on self-assessment basis in consonance with the provisions of the section 16. Furthermore, Your Lordships, a catena of High Court's decisions, be it Hana Medical, Suncraft Energy, multiple DI agencies, multiple High Court's cases, Your Lordships, it was held. I shall briefly state the verbatim and the ratio decision.
In the erstwhile VAT regime also, wherever the chain breaks, the liability increases. Similarly, under the GST law, wherever the chain breaks, automatically will it not freeze on the liability?
Your Lordships, I address the same concern in 1 minute, you may time much less. Now with respect to GSTR 2A, it was headed by multiple High Courts that the details in form GSTR 1 by a corresponding supplier in the facility in the same GSTR 2A by the recipient is in the nature of taxpayer facilitation and does not impact the ability of the taxpayer to avail ITC, which is the case with SSI and Your Lordships. Now, Your Lordships, I shall come to section 16 of Your Lordships, I will mention. Section 16, subsection 2 provides the conditions for claiming ITC, Your Lordships. I shall point-wise cover the subsection for us. 16(2)(a), Your Lordships, possession of valid tax invoice or debit bill. If Your Lordships may kindly refer to para 5 of the Moot proposition, I shall read it for Your Lordships' reference. Quote unquote, company had various supporting documents such as the invoices raised by the various suppliers, the bank statements to show that the payments have been made to the suppliers, proof of transportation, delivery of goods and services which were acknowledged by the company as a separate purchaser and suppliers through email and other delivery challans. Therefore, your lordships, 2A, 2B, receipt of goods and services, and 2D, filing of return by recipient under section 39 GSTR 3 dues duly filed by the recipient minutes. Therefore, A, B and D stands fulfill your lordships.
No, it is a conditional benefit, not your right. Okay? So that buyer beware, you will do vendor due diligence at the time of purchasing. Okay.
It's auto-populated, you can't avail with that.
Your lordships, that's a very valid concern. The very fact your lordships mentioned, it is auto-populated. It was the default of a third party, the supplier, who failed to put the invoices in GSTR to 1, due to which we are suffering and now cannot claim the benefits of ITC, your lordships.
If it is just failing to upload the return, that's okay. They have not paid the taxes. You are asking the government to give you credit of taxes which they have not received. That's the problem.
Your lordships, I shall address this concern in 2 points. Your lordships, firstly, your lordships, in the case of mentioned BVAT Act, your lordships, multiple high courts of your lordships, multiple decisions of the Delhi High Courts arising via Shantigaran on-base merchandising dealt with section 9(2)G, which is analogous to section 16(2)C. And I shall read the ratio descended at your lordships.
But in that council, there was no related to the supporting documents. There was no concept of this 2A3B in the erstwhile Delhi VAT Act. But there is a conscious provision which is there. When you say that you have fulfilled 62A, B, D and E, barring C, which is the crucial one. Now, still it is fatal to you, right? Unless that crucial fulfillment is also not done.
No, the council has 2 submissions to make. First, the limited aspect in which the council is using the Delhi High Court cases of section 9(2)G DVAT Act is to point out the fact that there is a failure on part of the legislature to make 16(2)C. But now the problem with 16(2)C is that it treats the bona fide purchasers and the fraudulent purchasers. The bona fide purchasers who have the proof of the transportation, the receipt of goods and services, bank statements of the transactions, your lordships, and fraudulent purchasers who want to tax
Do you think it is difficult to fake all the supporting documents? When an invoice can be faked, why not the e-way bill? Why not bank statements? Non-existing persons are there who have bank accounts. So all the documents which are required in section 16(2) can be faked. That is the experience of the department. Therefore they say that unless I realize the money, I will not be in a position to grant you ITC. It seems to be very genuine. Merely because you have some documents which may also be faked, may not in your case, but it is possible.
Now, since your lordship's concern deal with as to whether the tax reaches the kitty of the government, if you may be generous, the issue is a bit lengthy with respect to what it now your lordships, with respect to as to whether the tax reaches the kitty of the government. Oh no, your lordships, it didn't. Why it didn't, your lordships? Due to the failure of a third party supplier. Now your lordships, with respect to 16(2)C, the condition is tax should reach the kitty of the government. Now there is a failure by the parliament to construe 16(2)C. It places an obligation on the purchaser to ensure that the supplier indeed pays tax to the government. Whereas supplier, the purchaser in our capacity have ensured that we have bank statements. They can be indeed forged, but however, the emails of the transaction, the delivery challans, the invoices, the supporting documents, exact dates and times of delivery, whereas together construed, whereas it cannot be a false case and whereas it's a clear bona fide as it is an admitted fact.
There is this clause C, right? Why do you say the legislature has not conceived then? What do you mean by that?
Your lordships, what I mean by that is there are 2 groups of purchasers. The condition that purchasers are supposed to fulfill is the payment of tax. Now there are 2 kinds of purchasers. First, who have paid the tax to the supplier. Whereas the supplier did not pay the tax to the government for any reasons which we as purchasers are not aware of.
Is it your case that C doesn't apply to the relevant financial year?
Your Lordships, 16(2)(c) does apply to the financial year 2018-19. However, it is construed in a manner that it puts the liability of ensuring the fulfillment of statutory obligation of a third party. Your Lordships, we in our capacity as purchasers cannot ensure that the third party fulfills their obligation.
Have you challenged that information?
Your Lordships, that challenge,
So you are accepting it, right? But you do not challenge it. When you do not challenge this cost sake of its validity or unreasonableness, how can you still say that you do not follow that?
My lords, as it is held in multiple high courts as by the Instacart services of the Karnataka High Court, shall I read the ratio descendantile of one of the cases of your Lordship? My lords, so it was what we in our capacity are asking is not reading down of 16(2)(c). Reading down of the 16(2)(c) in a manner that it allows bona fide purchasers who have in support all the bona fide documents, which is an admitted fact by the department, by the single judge bench, by the division judge bench of the Karnataka High Court. And therefore, your Lordships, the third party default of a supplier not to put their invoices and pay the tax to the government, which we have absolutely no control over, cannot determine our due right of payment.
Considering that, the Supreme Court in ECAM has dealt with the same input credit and has clearly held burden is ordered to discharge and there are various parameters.
Indeed, your Lordships,
2 minutes, final.
if I'm correct, your Lordships are referring to section 155, which places the burden on the purchaser, your Lordships. Valid concern, your Lordships. However, what we are asking for is that in cases of bona fide purchasers, wherein we have all the verified documents and third party default should not determine our statutory right of claiming ITC, your Lordships. If your Lordships are satisfied and do not have any, and similarly, there have been a getting of High Court's decisions, be it Suncraft Energy, National Trust and Instacart Services. Therefore, we today, come to go down to the wisdom of your Honourable Lordships to read section 16(2)(c) in a manner that allows bona fide purchasers their due right to ITC. Which is the need of the hour. With this, if you are satisfied, the council seeks.
Whether they are satisfied or not, we will know later.
The council goes down to your Lordship's judgment. In my limited capacity, I can make the arguments. It's upon your Lordships to decide the veracity of the arguments.
Yes, sir.
The council shall now proceed to the prayer. If it is most respectfully prayed, what we please do. First, declare that the notification number 56/2023 was ultra by section 168 of the CGST Act. Second, declare that the impugned order passed by the department was well beyond the period of limitation. Third, declare that the non-repatriation of foreign exchange was within the period of repatriation and the purchaser should be provided with the export benefits. Third, declare that the non-mentioning of ITC by the supplier should not deny the right of ITC in the hands of the purchaser in case of bona fide purchaser merits. And fifth, direct the respondent to forfeit and grant the ITC and the export incentives which the departments want to recover, and or pass any order which your Lordships may deem fit in interest of justice, equity and good conscience. It was a pleasure arguing before the Honourable Bench. Much obliged to us.
Acknowledging the presence of your ladyship, the council seeks permission to address the bench collectively as your lordships. Greetings to the bench. This is council number 1 representing the respondents. I'll be dealing with issues 1 and 2, and council 2 will be addressing issues 3 and 4, your lordships. If the bench requires, the council will provide a brief of the facts.
Facts, skip the facts, they have already.
Much obliged, your lordships. Addressing issue 1, your lordships, mainly regarding whether the notification number 56/2023 was ultra via section 168 of the GST Act or not. Your lordships, the respondents humbly submit that the notification number 56/2023
was not ultra vires of Section 168A of the GST Act, and it is a valid and lawful exercise of power conferred upon the central government under Section 168A of the GST Act. Section 168A is an enabling provision that empowers the government to extend time limits in cases of force majeure such as COVID-19 pandemic on the recommendation of the GST Council. The appellant's challenge in this particular case is primarily premised on the contention that such a recommendation must necessarily precede the issuance of the notification. However, such a rigid interpretation defeats the very purpose of the provision itself, Your Lordships. If the Council could direct your attention towards flag B of the compendium, Your Lordships, in the case of Popatlal Shah versus State of Madras, the Honorable Supreme Court emphasized that while charging provisions in taxation...
Let us first take it 1 second. Which flag was that?
Flag B, Your Lordships.
Is this your compendium?
Yes, Your Lordships. Your Lordships, in the first page itself, it has been mentioned that to ascertain the legislative intent, all the constitutive parts of a statute are to be taken together, and each word, phrase or sentence is to be considered in the light of the general purpose and object of the act itself, Your Lordships. So based on the intent of the lawmakers before creating this, there was no intention to particularly harm any of the parties involved. So when we're looking at the essence of the act itself, the respondents are humbly putting forward that we have not misemployed 168A, but rather we are in concurrence with the essence and the main aim behind creating the act itself, Your Lordships. The constitutional position of the GST Council makes it very clear that its role is recommendatory and advisory, and it is not completely binding upon the Union or the states. Your Lordship, if the Council could direct your attention towards 168A, Clause 2, Your Lordships. Clause 2 has specified that the power to issue notification under subsection 1 shall include the power to give retrospective effect to such notification from a date not earlier than the date of the commencement of this act itself. So based on the facts and what has happened in this particular case at hand, the notification was duly ratified by the GST Council after it was passed. So this is not completely against the government itself or not completely against the intention of the act itself. Hence,
the appellants clarified that is on the retrospectivity of the application of the notification.
Yes, Your
That's what subsection 2 refers to. That does not deal at all with regard to the procedure which is prescribed under subsection 1. Procedure is recommendation, and then it has to be issued. While issuing, it can be backdated. That's what subsection 2 is. But in your case, the notification has not been issued retrospectively. It is prospective, but it has not obtained the recommendation of the council, which is mandated under subsection 1. So that is what that they are challenging.
Yes, Your Lordship. The Council understands, Your Lordship. Based on what Your Lordships have mentioned now, it is not that the GST Council has completely not ratified it. The GST Council did end up ratifying it in the end. The government made the decision to pass the notification in the first place with the help of the GST Implementation Committee, and later on this was ratified by the Council. Hence, the Council of the respondent side don't see any flaw in passing the notification as it is, and it is not ultra vires of its powers is what the Council is trying to put forward before the Honourable Bench.
Madam, you have notification with you? You have
56
copy of notification 56 of 23?
No, Your Lordships.
Please provide if it is there.
Does the appellant council have? Which page is that?
Page number 31, please share to your friend. Madam, read first line.
Yes, Your Lordships. In exercise of the powers conferred by Section 168A of the Central Goods and Service Tax Act 2017, hereinafter referred to as...
Leave remaining.
Yes,
Then now come to fourth line, last fourth line. After 31st March 23, the government.
Last but four.
Last 4 lines, which is after 31st March 23 on the right hand extreme right side.
The government on the recommendation of the Council hereby
Which is that recommendation?
Your Lordship, in this case, the recommendation has been taken from the implementation committee itself, and that cannot be completely overlooked, Your Lordships. After this, the council did ratify.
Misleading? Is the entire notification not vitiated by fraud?
No, Your Lordship, the entire
Because
notification.
it's not based on recommendation. Do you agree to that extent? That's what the Lordship points out. How can you use the word recommendation there, and on the date of the notification, no recommendation was obtained?
Your Lordship, it is true that the recommendation was not taken before the notification was passed, but this was mainly due to the existence of COVID-19, and due to that there was a fault on the part of the respondents to properly construe a meeting and get recommendation of the GST Council itself. But later on, the GST Council did accept the notification. Hence, how can it be completely declared invalid or
Are there
void
any
after?
rulings, a legal argument saying that this is only procedural, it's not a substantive thing? Do you have any rulings to support your case?
Yes, Your Lordship. Your Lordship, in the case of Union of India versus Moot Minerals Private Limited, it was held that the recommendation of the GST Council has only persuasive value and it does not possess complete binding force. This was mentioned in flag C of the compendium, Your Lordships.
That is on the word may. Merely because the council recommends, that does not bind the government to issue the notification. To that extent, this judgment may help you. But on the procedural aspect, if there is an error in the procedure to be followed, is it something which can be condoned? Do you have any case laws to that effect?
Your Lordship, in this case, the fact that they could not abide with the procedural aspect is a curable defect. It is not going completely against the merits of the case at hand itself, Your Lordship. That is what the council is trying to put forward. And in terms of a case law, Your Lordship, in the case of Lalchand Bhimraj versus CESTAT, this mainly focuses, this case is being put forward mainly in terms of the doctrine of substantial compliance. So the critical question that is to be examined when any notification is being passed or anything is being passed is whether the requirements relate to the substance or essence of the thing to be done, but are given with view to the orderly conduct of business. They may be fulfilled by substantial if not strict compliance. So in this case, substantially they have followed each and every aspect of the notification. In the sense, 168A has two major essentials, starting off with the GST Council's recommendation, as your Lordships have mentioned, and the opposite party have mentioned, and secondly, the existence of force majeure. So the respondents have duly complied to the maximum extent possible in that situation with all the conditions mentioned.
Could you please read notification number 9, 26th July 2023?
Yes, your Lordships.
Notification number 9, 2023. And it says it cannot be extended beyond 31st March 2024. That is the GST Council's recommendation and decision. Can they overrule their own decision?
Your Lordships, we have not overruled that decision, Your Lordship. We are in compliance with the notification.
Will it not amount to violation of Article 265 of the Constitution? Because GST Implementation Committee has no authority, only GST Council. But GST Council, it is post facto ratification. It ratified only in June 2024, whereas the order is dated 30th April.
Yes, Your Lordship.
Then without authority of law, can they do it?
Most definitely.
And again, violation of Article 14, how can they collect tax? It should be equal for everybody. If they go on issuing notifications like that, and that chain can continue, where is the end?
Your Lordship, is the Lordship referring to the time of COVID-19 as the time?
No, that's over. Supreme Court has given the
yes, Your Lordship, to recognize.
And later on, again, that 3 years, that time is also over.
Yes, Your Lordship. However, Your Lordship, fundamental rights have not been violated in this case in terms of Article 14 or the Council has a case to present which is in coherence with what Your Lordship mentioned earlier.
Madam, one more question on this.
Yes, Your Lordship.
As per section 7310,
Yes, Your
the
Lordship.
time limit expired
Yes, Your
December
Lordship.
22.
Yes, Your Lordship.
So the notification is dated 28/12/23.
Yes, Your Lordship.
So what happened in between?
Your Lordship, due to the presence of COVID-19, it was difficult for the revenue to pass a notification at that point of time. But to the extent possible, we made the GST Council ratify the decision immediately within 1 month of the passing of the notification, within a short period of time.
No. Was there any continuity or there was a break in?
There was a small break, Your
No.
Lordship.
Was there any extension of 31st December 22 before its expiry, or extension was made after it was expired?
The extension is made after its expiry, Your Lordship, after 2022.
Is it permissible? Will it not create a vested right in the taxpayer? Can you take away that whatever the statute vests right, can you take away with your subsequent action? Is it not arbitrary?
Yes, Your Lordship. If the action is as Your Lordship mentioned, it is definitely
Maybe you are
arbitrary.
competent, your competency to extend before expiry of the earlier period.
Yes,
Once
Your
it
Lordship.
expires, it
Yes,
definitely
Your
vests with the right with the taxpayer. Can you take away with your subsequent action?
Your Lordship, it is true that it is arbitrary use of power if we take away the power of the
You
taxpayer.
admit it is arbitrary.
But Your Lordship, in this case, the respondents have not done the same. We have not tried to arbitrarily use power.
What prevented you from not extending it?
Your Lordship, the force major situation is what
You were
prevented
able to
this.
issue notices during the peak of it. Look at the number of notifications issued in April 2020, and it is July 2022, subsequently March 23. Your own notification refers to various previous notifications. So there is a lacuna, right? Almost 1 full year you thought the taxpayers that you have given up for assessments relating to financial 18-19. Then comes a surprise.
1 second, Your Lordship. Your Lordship, it is true that a break period did come in between all of this, but the revenue took whatever steps possible in that stage of time to address the issue immediately. So we passed the intimation through email under section 61. Despite that, there was no response from the side of the appellants. Then we went for the show cause notice in the following year, and we weren't getting any proper response from their side as well, despite the long time period taking place. So, Your Lordship, it's not just the respondents that have extended time, even the appellants themselves have extended the time period even further.
No, invoking force majeure, that is act of God, like natural calamities, COVID, etc. What was your plea? It was administrative backlog,
Yes.
lack of manpower. Can you invoke force majeure clause for that?
Your Lordship, in order for any department to function properly, it is required for the administrative process to have manpower and to be able to function on full-fledged. So COVID-19 curtailed that. It was a pandemic, an unfortunate one. So it completely curtailed the functioning of the department itself. Hence, it was very difficult for the department to file the intimation in the first place. But despite that, despite all the existing circumstances, the department tried to do it as soon as possible. It is true that there has been a significant delay, but there was a lot of efforts from the side of the department to ensure that it comes out on time with whatever situation was present at that time.
Can the dead cause be revived?
Apologies.
Your right to extend
Yes, Your Lordship.
was dead as on December 22. Can it be revived?
Yes, Your Lordship. It can be revived.
As soon as December 22 passes,
Yes.
right to extend.
Yes,
To
Your Lordship.
extend, something should be live. Your
Yes.
cause was dead.
That's right.
Today you can make it to 2030. And your GST Council proceeding says officers face difficulties. What will happen to the rights accrued in favor of the taxpayers? Can it be one-sided?
No, Your Lordships, it's not supposed
You admit
to
it
be
is
one.
arbitrary?
No, Your Lordship.
Absence of fair play?
Your Lordships, it is true that this may be detrimental to the taxpayers itself.
Yes.
But Your Lordship, it was not the intent of the respondent side to do any action that is going against the taxpayers itself. The intention was to ensure that both the exchequer and the taxpayers are able to enjoy rights equally. So since we were trying to achieve our own rights, it may have led to a possibility that...
Will it not amount to shifting of goalpost after the race is over? You complete your race and then you say goalpost is this. Is it permissible, shifting of goalpost? While the race is on or before race commences, you can shift your goalpost, but not after completion of race.
That is true, Your Lordships. Your Lordships, before ending the argument, Your Lordship, Taxation and Other Laws Amendment Act was introduced in 2020. In that, Your Lordship, the concept of deemed fiction was introduced. In deemed fiction, it was stating that the basic meaning of deemed fiction is in case of situations where any timeline is not properly stipulated, or in cases where the court is not able to completely comply with the truth, it may choose to believe a partial truth and pass an order based on that. So, in the case of Rajiv Bansal versus Union of India, this deemed fiction concept was covered. The council is trying to invoke that and employ that in this case as well, where there is a deemed fiction situation existing in this case, which is why the councils were not able to abide with the timeline completely, and we chose to employ a timeline after the existing 3-year limitation period, Your Lordships. If the bench permits, the council move on to the second issue.
First and second issue are overlapping. I mean, it's the same argument.
Yes, Your Lordships, it is similar. Just to wind up.
But what is this deemed fiction concept in Rajiv Bansal that you are talking?
Your Lordship, the deemed fiction concept is mainly pertaining to in case of situations where a timeline is not properly stipulated, or there is no stipulation regarding how much extension exists, the court may choose to believe a fact that is not completely true, and it may grant an extension in certain situations. That is what Rajiv Bansal versus Union of India case put forward, Your Lordship. It is also known as legal fiction or even deemed fiction.
Now your case is 7310, there is an ambiguity. Your case is 7310,
yes.
Suffers from ambiguity.
Yes, Your Lordship. It is having ambiguity, Your Lordships.
So how ambiguity should be clarified?
Your Lordships,
is it by legislative action, or can the ambiguity in parliamentary enactment can be clarified by executive actions?
It should be with legislative.
Where is that power? Where is that power?
With the legislature.
Where is the power to clarify the enactment?
The power lies in the hands of...
in this case. You are canvassing a proposition that ambiguity in 10, subsection 10 is clarified by circular.
Yes, Your Lordship.
Where is that power vested with the government or the authorities who have issued that circular?
Your Lordship, the ambiguity is not pertaining completely to the timeline itself. The ambiguity is mainly with regard to whether the work could be completed within that particular point of time. That's what the council is
doing. Can that be traced anywhere in this language, text of either the circular or the minutes of the meeting?
Your Lordship, there is an ambiguity.
No, as a government council, you have to go by your statute or the actions.
Yes,
you will not have that luxury of that what the appellant council exercises.
Yes, Your Lordships.
And having chosen section 73 for the show cause notice,
yes,
you know the time limit was 3 years.
Yes, Your Lordship.
And you should have served the show cause notice 3 months in advance of the due date. Say that was 30th of September 2022.
Yes,
but
Your Lordship.
you served it 4 months later, and even after 3 years. Otherwise, if you wanted more time, you should have served under section 74. You would have got 5 years. What prevented you from choosing section 73 instead of section 74?
Your Lordship, section 74 mainly pertains to in case of fraud or any aspect regarding that. But the council is not going to, that timeline is not being employed in this case. The council chose to employ section 73, clause 10 itself.
The appellants have not committed any fraud, according to you.
Your Lordship, there is no exact explicit mention of commission of fraud, but definitely there was non-payment of expatriation.
So you're keeping that open. There is no fraud element in that, because you're able to retrieve all the details only from their own filings. They did not suppress anything. That's why you consciously invoked section 73.
Yes, Your Lordship. The main focus over here, rather than the fraud, is with regard to non-response to the show cause notice and even to the intimation itself, Your Lordships. Your Lordships, if may the Council proceed with issue 2 and completely
Yes.
wind up. Your Lordship, issue 2 can be mainly divided into a few limbs, which is starting off with the validity of the extension notification itself and how post-facto ratification is valid. Your Lordship, in the case of Sahaj Construction versus Union of India, as mentioned in flag H, in this case, the timeline is different from the case at hand, but it has been mentioned that it is possible to extend time limit under Section 73 Clause 10 based on the GST Council's recommendation once accepted by the government, and it cannot be challenged by the SSC further. Similarly, Your Lordships, the next limb is with force major application and its justification. Your Lordship, the case of Graziano Transmissioni versus Goods and Service Tax mentions that since there was a spread of COVID-19 pandemic, that is force major, during March 2020 to February 2022, notification number 9/2023 of the central tax and notification number 515 had extended time granting to adjudicated authorities to pass adjudication orders with reference to proceedings of financial year 2017 to 18 up to 31st of December 2023. And the writ petition challenging issuance of impugned notification must fail, and in this case it was concluded in favor of the revenue itself. So based on the facts of the case at hand, passing the notification in the year 2022 would not be a viable option, and the date 30th of April 2024 will not amount to a significant delay is what the Council humbly puts forward. And Your Lordship, in terms of Your Lordships, can the Council ask for a few more minutes of the benches? Yes, Your Lordship.
Yeah, you can take 5 minutes. We have given them some time.
Thank you, Your Lordships.
5 minutes, you can take 5 minutes.
Thank you, Your Lordships. Your Lordships, the third limb is with validity of order and compliance with the principles of natural justice. In flag I, Your Lordship, the case of TVL NVR Sons versus Union of India has possessed a few elements in common with the case at hand, and the court held that extending the time limit under Section 73 Clause 9 was not invalid and was in consonance with the constitutional framework, as it did not violate any of the principles of natural justice, which still remain a primary concern. And Your Lordship, the division bench has rightly held that recommendation includes ratification as well, and in this case even post facto ratification will be invoked as well, if the bench permits the Council to
Yes, no, like Supreme Court had already given 2 years exclusion, 15 days short of 2 years. Further extending that time, will you not snatch away the rights of the assessee, the taxpayer, through notifications?
Your Lordship, what Your Lordship has put forward is completely valid, but Your Lordship, the Supreme Court itself has acknowledged the presence of a force major event, and it has introduced Taxation Other Laws Amendment Act. It has even introduced Notification 9/2023 and 56/2023, even though it was post facto ratification. The GST Council itself has acknowledged it and completely ratified it. Hence, the higher authorities and the apex court itself has established that COVID-19 persists and the revenue deserves some sort of leeway, which is what the revenue is trying to employ. It is true that there has been an extension of time beyond the period mentioned.
Section 73 subsection 2 SCN is not void, and again 73 subsection 10 order is also not void according to you?
Your Lordship, it is not void completely, but since this is not a normal situation, it is a situation of COVID-19.
So it is half void?
No, Your Lordships, it will not be applicable in this particular case, and this situation is what the Council is putting forward. It's not void at all, Your Lordships. If the bench permits, the Council would like to hand over the issue to the co-counsel. Much obliged, Your Lordship. It was an honor arguing before this bench.
May it please this honorable bench. This is counsel number 2 on behalf of the respondent. This counsel will be dealing with issues number 3 and 4 of the prop. Issue number 3 deals with whether the non-reparation of foreign exchange within the stipulated time on exports made by the company would result in denial of export incentives. Your Lordships, the counsel for the respondent hereby humbly submits that the non-reparation of foreign exchange within the stipulated time would in fact result in denial of export incentives in the particular matter. Your Lordship, briefing the facts that have led to this particular issue in the matter at hand, it is that the appellant company has been indulging in zero rated sales for a considerable period of time. In the financial year 18-19, where this particular issue occurred, several foreign buyers have failed to make payment to the appellant company, and upon failure of realization, the department has revoked the incentives that were otherwise available to the appellant company in question. Your Lordships, the appellants have relied on master direction and point C23, which they have earlier guided the bench towards, wherein the 10% reduction, stating that 10% is a mere triviality, was claimed by the appellant, seeking to write off that particular value. Your Lordship, though the prop remains silent as to whether this is a self write-off or an ED category bank write-off, this council would not like to delve into that, but simply would like to take one step backwards, where point C23.1 stipulates that best efforts needs to be employed in attempting to realize the amount back into the nation. Your Lordship, the single judge bench in this particular factual matrix has erred, and the division bench has rightfully corrected the same. The single judge bench has said that reasonable efforts were duly complied with. Your Lordship, this overrulement by the division bench is correct, where in fact the counsels of the respondent would like to reiterate that the term best efforts sets a higher and more rigorous standard as opposed to reasonable efforts in this particular matter. Your Lordship, for this very purpose, the council would like to rely upon international jurisprudence to understand the ambit of interpretation of this particular term best efforts. If the bench may permit, the council would like to direct the attention of the bench to flag labeled O of the respondent's compendium, Your Lordship, wherein the council has cited or extracted for the bench's convenience the case of atmospheric diving systems, wherein 7 principles have been detailed to explicitly discuss and to curtail the ambit of interpretation of the term best efforts in itself. Your Lordship, from an overall reading of that the principles as detailed in that particular case, it is clear that not only are the standards rigorous and higher as opposed to what may be said for the term reasonable efforts, it also entails that the appellant company at this juncture must ensure that no stones remain unturned, meaning that all possible efforts that is within their capacity must be employed. Your Lordship, at this further in furtherance of the same argument, in flag labeled P, the council has extracted the case of jet2.com for the convenience of the bench. In this particular case, it is further stipulated that where there is a financial restraint, the same cannot be cited as an excuse to leave the stones unturned. That is, to exhaust or otherwise avoid best efforts as otherwise stipulated in the provisions as detailed by the counsels for the appellant. Financial restraint cannot be used as a singular excuse for the same. Before the department, primarily that is the argument that is made from a brief reading of the factual matrix, that financial repercussions may be caused if the appellants at that juncture go and file legal proceedings. Legal proceedings is well within the usual and regular course of action that a particular company might take where there is a failure to meet contractual obligations, which is precisely the nature of the transactions between the foreign buyers and the appellant company at this juncture. But the appellant companies have still failed to litigate or take any legal action on this matter. Your Lordship, further, the division bench has been correct on factual, on merit basis to note that no extension has been sought from the RBI. At the instance that the appellant company was aware that
in this particular case, whether Rule 96B is applicable or not?
Your Lordship, in this particular case, both goods and it's stated that software, though generally is interpreted as a service, both goods and services are being used by the appellant company, Your Lordship. The nature of the good in itself, that is whether it's a service or a good, is something that can keep fluctuating depending on the nature of the sale in itself as well.
No, this is software, there is no confusion.
Your Lordship, in this particular for a service, in layman's understanding, Your Lordship, a service stipulates that there is a persistent direct connect with the supplier. That is where a service, the supplier physically is involved in the process of granting a service to the purchaser. Your Lordship, in this case, it can be understood from the facts or interpreted from the facts that though there are services involved as well, where the particular foreign buyers are concerned, post sales there has been no communication, meaning the starting and ending has stopped with sales.
No, in fact, answer the question whether.
No, have you understood? Please understand.
Indeed, Your Lordship. Your Lordship, in the case of TCS versus State of Andhra Pradesh as well, it's been stated that the nature of this particular good, whether it's a service or a good, can change as per facts and circumstances, Your
In
Lordship.
this particular case on hand, is there any goods supplied or exported?
Your Lordship, in certain instances where the facts are vague and ambiguous as to the nature of the actual sale or the nature of the software.
When can software be treated as service? When can software be treated as goods?
Indeed, Your Lordship. Your Lordship, in layman's terms, an example, if the council may, for better understanding.
Legal. I think none of us are laymen here. So you can make a legal
Your
argument.
Lordship, for better understanding, and in the interpretation that the council has understood these terminologies as well. Software is as a service when the software is used by the company for purposes of their own. That is, the purchaser uses the particular software in the regular course of their own business, in which case it is a service. It furthers their business in itself. But where it is considered a good is where the entirety of the software is purchased, and further services are granted by the purchaser at a later juncture to other purchasers thereof.
You relied on a case law, right? State of Andhra Pradesh versus TCS. What does it say? What is the ratio?
Your Lordship, one moment.
If it is offhand, fine, but otherwise you can proceed.
Your Lordship, here it's the understanding is that depending on the capability of usage, the nature, that is whether it's a goods or services, can be interpreted. Your Lordship, in this particular matter, the counsels for the appellant have also interpreted that it is a service and furthered. But regardless, the write-off that they are claiming under both 96A that the counsels for the appellant have relied upon.
Use of or giving license to use a software, right to or license to use a software, is it goods or service?
Your Lordship, the license itself will be a service because ownership is retained by the supplier in the instance. But where the software in itself is sold in its entirety, including ownership as well as control thereon forth, to the purchaser, it can be treated as a goods. The nature is depending on facts and circumstances.
If it's through a medium, it can be goods. That's what the whole judgment is.
Indeed, Your Lordship. Wherein the facts are silent as to what nature of this particular sale, to what extent the sale has been made. Therefore, the counsel in the written submissions is related upon 96B, whereas the counsels for the appellant have contrarily stated that it is a service. But there is no dispute to this regard that the counsel for the respondent at this instance would like to address, because regardless, all the arguments, both detailing from 96B.
No, you was arguing that RBI permission was not sought. That's why I posed the question.
Indeed, Your Lordship. Your Lordship, here an RBI extension has not been sought, which has been denoted by the division bench in the impugned order in question, Your Lordship. Your Lordship, the counsel details that particular point of merit to emphasize that reasonable and usual course can be taken. Where the appellant company was aware that realization at a particular point of time was not foreseeable, or was in fact possibly the buyers were going untraceable, they were not at a position to realize the same. At that very instance, the appellant company through best efforts had the reasonable duty to inform the RBI at this juncture that the realization would in fact become impossible, and therefore if the RBI and extension may be duly sought, and if the RBI felt the same necessary, the discretion of the RBI could have been exercised at that juncture to determine whether necessary or not. It is not for the appellant company to determine for itself whether an extension is necessary or assume an impossibility and proceed. Your Lordship, on basis of merit, it's also previously stated that the buyers with whom they have indulged in these transactions, there were no prior transactions with these particular buyers, there was no prior investigation or anything, there was no means to communicate upon non-realization.
In case of new business penetration or promoting, will you go on investigating each and every buyer? Can you expect?
Indeed not, Your Lordship, but at the same instance, due diligence must be exercised by the appellant company to ensure that there is a higher rate of possibility that there is a bona fide buyer with whom they are interacting. That is due diligence, and that is the most basic level of diligence that can be exercised by the appellant company. At the very first instance, the appellant company must also ensure that at the very first instance, before the sale is made, that possibility of realization of the exports is higher. all the while knowing that there is higher chance of realization not being made, the appellant cannot forego their diligence or forego their responsibility in ensuring the same.
Here the appellant has lost the money. He has written it off in his books of accounts, not recovered as bad debts. He has lost the whole money. Sale proceeds itself is lost, not the ITC. So you are recovering tax from him. He has already lost the sale proceeds.
This point is precisely where the counsel for the respondent would like to differ by saying that write-off in itself is available to them as a right only where they have shown proof. Under 155, as the counsels for the appellant themselves led us towards, Section 155 clearly states that the burden of proof lies upon them to prove that they have in fact exercised best efforts and all possible means within their capacity and still have failed to realize that at this juncture they must be able to prove that it is no longer within their control. No matter what method they exercise, it is an impossibility for realization. Is precisely the standard of proof that the appellant company at this juncture must fulfill, which they have failed. They have simply stated that they have taken one or two efforts including emails, they have tried to contact through the consulate. Your lordship,
through accounting entries you can check that they have written off. Through audit you can find out in their balance sheet it is written off. Through ROC returns you can find that it is written off. Enough proof is there now.
Your lordship, here the question at debate is not whether there has been a write-off, but rather whether there was a right of write-off, whether the appellant company had the right to write off that particular 10% amount in their favor to thereafter say that it was in fact a trivial amount.
What they did by writing off is they were not able to realize to the extent of 10% of the exports.
Indeed,
so they are writing it as they will not be able to recover it.
Indeed, your lordship.
So therefore that becomes actually a cost for them.
Indeed, your lordship.
Now, how do you say that they do not have a right to write off? It's a business decision.
Your lordship, it's clearly stated in point C23 which they have referred to as well. There are certain stipulations that are made. For self write-off for above 10, below 10%, that is between 5% and 10%, there is a status holder symbol that they have to present before the department. Further, they have also stated that they have approached an AD category bank. Your lordship, for all of this to be same, the notion at the first instance, before any of these stipulations that they have dealt with even come into consideration, is that best efforts must be employed. Without best efforts, the principles of natural justice are not in compliance with. At every instance, the appellant must act in bona fide to prove that they have done everything within their capacity, which in itself has not been proven in the matter at hand, your lordship. So it is not a question as to whether it's a discretion or that the business may employ at its own accord, but rather where they are relying upon C23 and the stipulations under the same. It is not just the merit-based stipulations under C23, but rather the jurisprudential argument that the term best effort sets a very high and rigorous standard that has not been complied with.
How much is good enough is a commercial decision. Maybe you have a point in saying that they did not inform the RBI that they were not able to recover. There you have a point. But we are not convinced with the fact that they should have done. You cannot sit in the armchair of the taxpayer to say you should have done A, B, C, D. Because when the defendant itself is unapproachable or if it's inaccessible, there's no point even filing a suit, right, in a foreign country.
Your lordship, at this, which is precisely why the council redirected to state that at the very first instance, due diligence must have been appointed by the appellant.
You have heard, on that point you have heard.
Indeed, your lordship. Your lordship, the department in its holding in the first instance is also held that on the basis of merit, the best efforts clause has not been complied with because of the fact that it's not sufficient to simply be able to contact them. But there must be some effort on the appellant's part to ensure that the repercussions faced by the buyer. In fact, they must go as far as forcing or compelling the buyers to return, which is precisely what the term no stone unturned entails. That is, all possible means must be exercised duly. Your lordship, here they are merely citing a financial restraint for not filing suits. They have stated that the proportion is different, in fact, in their oral arguments, which is arbitrary because they have nothing to the extent to prove that it will in fact be disproportionate or what the results of such litigation might entail, which is still unknown to the appellant at hand. Given the facts and circumstances, the appellant is well within its capacity to start take legal action against their foreign buyers. to have taken diligence in the first place. There's a window of opportunity that the department has in fact given them by giving them the opportunity to rectify, which the appellants have also failed to use, and further the lack of extension being sought, which has been duly noted by the division bench.
Move on, Counsel.
If the bench is satisfied, the council would like to proceed with issue number 4 at this instance. Your Lordship, issue number 4.
Before you go to issue number 3, you don't seem to have taken any cue from the questions that we have asked them.
Your Lordship,
Your arguments, you have, as a counsel sitting on the other side, when we are asking questions to them, you should catch on those questions. And
Indeed,
just
Indeed, Your
advice
Lordship.
for the
council wanted to first read into the arguments that the council
So
has.
you have not covered the definition of export of services, which is in your favor.
Your Lordship,
Basis
the
the
council would, once covering the written submissions in its entirety, would like to take one moment at the end to answer both the issues that have been posed to my co-counsel.
Both the parties have spent too much time on reasonable efforts. According to me, I mean, we having practiced both direct and indirect reasonable, reasonable steps to be taken is more relevant for the purpose of writing off of bad debts. Can you ask the GST department to give you refund of unutilized input tax credit when
Where it does not
it is
entail
not
an
an
export in itself under 2 clause 6, Your Lordship.
That-
The council is aware of
That's the
that.
point, isn't it?
Your Lordship, the council is aware of the
More of legal arguments, saying that non-fulfillment, this is a tax statute.
Indeed, Your Lordship.
Non-fulfillment of a condition, they
In
have to
itself
lose their
voids.
benefit. Rather than trying to determine or trying to establish the yardstick what is reasonable efforts or best efforts. That's very subjective.
Your Lordship, precisely, the council is well aware of the provision under 2 clause 6. But the line of arguments that the council has chosen today is derived out of the lower court orders, that is the litigating journey that has been previously entailed, that is department's order, single judge. It has been repeatedly disputed by all of these lower courts, that is the department has also taken a stance on this interpretation of best effort. The same has been overturned by the single judge, and it's this very point that was again brought about in the impugned order and reversed, which is precisely why the council directed course of arguments towards the interpretation of best efforts to simply state that where this impugned order is concerned on this particular matter, the reasoning given by the division bench was that this extension was not sought, meaning there was a merit consideration that the division bench had taken that has been disputed by the appellant, Your Lordship, which is precisely why at the SLP stage we would like to address the impugned order and the whatever wrongfulness the appellants have addressed with this particular impugned order. In the impugned order, it has been stated that this is the question in debate.
Next issue.
Madam,
Indeed, Your Lordship.
before going to next, what is the incentive government is giving here?
Your Lordship, it's considered a zero-rated sale.
What is that incentive? Incentive to export?
It is an incentive to export and
Export you are not disputing?
indeed, not Your Lordship. We are to the extent of 90%, we are not disputing, Your Lordship. We are simply saying that this at this juncture, if the Supreme Court holds that this 10% can be written off without reasonable effort shown by them, it shows perversity.
No, section 16 of IGST is an incentive provision.
Indeed, Your Lordship.
What is that incentive you are giving?
Input tax credit, Your Lordship.
No,
that is
incentive is refund of input tax credit is an incentive to the export activity.
Indeed, Your Lordship.
You are not disputing the export activity.
Your Lordship.
Substantial compliance is of the incentive. The activity is complied here.
Indeed, Your Lordship. The council in fact does dispute the nature of export in itself under 2 clause 6, like as the bench had previously questioned the councils for the appellant on. But at this juncture, the council is not denying the right of write-off. That is, to the extent of 90%, the councils have argued that it is in fact an export, and to the extent of 10% it is not.
Council, what the bench wants to know is, it's a procedural requirement, bringing in foreign currency.
Indeed, Your Lordship.
You do not deny the fact that the services have in fact been provided to a foreign purchaser. Do you accept that?
To the extent of 90%.
100%. No, it's not. Are you saying
Indeed
that,
not, Your Lordship.
No, are you saying that is it your case that the 10% it's a fake export?
Indeed not, Your Lordship. The council is saying that there has been non-realization and
that is what? That is.
Madam, you have showcast. What is your case? You should be clear first before
Indeed,
eliciting answer from the taxpayer. You should be clear.
Indeed, Your Lordship.
What is that you are asking? You are asking is you have taken refund
Your Lordship, it is a
and nowhere you have disputed the export activity. Genuineness of export activity is not under dispute.
Your Lordship, the genuineness of the at this juncture, the counsels for the appellant try to distinguish that upon 10% write-off, the remaining 90% will be considered as an export, Your Lordship. Where this 10% cannot be segregated through write-off, the entirety will fail to be an export, and therefore incentive is denied at this particular.
Then 74 comes into play.
Indeed not, Your Lordship. We are not questioning the bona fide nature. We are simply saying that per procedure, where it is not complied to be an export, it must be refunded back to the department in itself. It's a mere procedure. We are not questioning the bona fide nature, or we are simply stating that we are not questioning the reason for which the appellant has entered into this particular transaction. We have not questioned their fraudulent intent or anything of that sort. The department here is merely trying to ensure that by giving them an unreasonable right to write off and claim and segregate this 10% from the remaining 90%, there is no perversity that is caused because of the same. For the larger interest of the public, it must be retained that unless an extraordinary situation is proven, the same cannot be allowed, and that extent of burden of proof has not been fulfilled at this particular point of time. The department at this instance simply claims back or claims the refund upon the incentive otherwise provided, and does not further would
incentive of how much, 10% or entire 100%?
That was my question also. Are you going to deny refund only for the extent of 10%?
Entire 100%, Your Lordship, because there is a high standard of proof that needs to be fulfilled for the right for that 10% right to be availed. Otherwise, every person exporter will now come and claim that it's below 10%.
Why your act treats each supply as a separate transaction, isn't it? How can you deny the remaining 90% also? 90% is exports. They have realized the consideration.
Your Lordship, the export is viewed in its entirety. This segregation is permitted only where there is a write-off, where no longer it is connected to in its books. Your Lordship, if the council may.
Council, are you saying that there was only one invoice throughout the year? Let us understand first whether you have understood correctly. Throughout the year, is it your case that there was only one invoice raised?
Indeed not,
and of that 90% was paid and remaining 10% was not paid?
Indeed not, Your Lordship.
So it is possible that there could be multiple purchasers in different countries.
Indeed,
so there have been proper payments by those purchasers. Why should the benefit be denied?
Your Lordship, though there may be several transactions, there is precisely one supplier and one claim for ITC. There is one declaration that they have made stating the entirety of their total exports and claiming. This ITC claim is not done per transaction, but in proportion to the total exports that the supplier as one individual has entered into in a particular financial year, Your Lordship. At this instance, it is the duty of the supplier to ensure diligence not just in one or two cases, but in all of its cases, to ensure that they remain a bona fide exporter. If the RBI was aware previously, they could have even put them in the caution list, Your Lordship, which is precisely where that concept comes in, where the RBI, there is one supplier who needs to take equal diligence in all of its supply activities and all of the transactions, which has not been maintained. This cannot give the other exporters the leeway to say that to the extent possible they will exercise best efforts and otherwise they will not, which cannot be the false notion that is given to the public, which is precisely what will be done at this instance. If without due efforts being fulfilled in its entirety, the right of leeway is given to the appellant.
What is the definition of business?
Your Lordship, business would entail engaging in a particular market activity, and in the due course of such business in itself, they will engage in sales, purchases, etc. with several buyers.
With an intention to?
With an intention to make profit.
Or loss?
Indeed, Your Lordship.
Okay. Profit or loss?
Indeed, Your Lordship.
When that is the case, their businessman will be running a risk of loss also. Who has to bear the loss?
The business in itself.
Just because he has lost 10%, you want to tax them 100%?
Your Lordship, here...
is it not just? Is it fair?
Your Lordship, business is not for the purpose of loss, but rather the loss that has occurred during the course of business will be duly accepted by the appellant. That is not in dispute by the company.
Accepted by the appellant or the department?
Your Lordship, to the extent of the non-realization by the appellant in itself, Your Lordship, but In every due course of business, the primary intention is to create a profit, meaning to, as far as possible, the appellant company must try to reduce the amount of loss, which is the extent of proof that has not been fulfilled in this particular.
What evidence you have to prove that they have not made any effort to reduce the loss or recover the amount?
Your Lordship, the burden of proof lies upon the appellant at this juncture to prove that they have in fact taken it. Reasonable doubt has been well established by the respondent here, but the burden of proof entirely lies upon the appellant, which they have not fulfilled in its entirety.
You can go to next question.
Your Lordship, the counsel would like to take 5 minutes as the counsel's time. Much obliged, Your Lordship. Your Lordship, with regards to whether the non-mentioning of the ITC on the supplies made by the supplier in its GSTR 2A would deny such ITC in the hands of the purchaser. This is the fourth issue at hand. The facts that have led to the same are that GSTR 1 is a form that is filled by the suppliers, wherein they have detailed all supply transactions that they have entered to in a particular period of time. GSTR 2A directly in an automated manner reflects the transactions wherein the purchaser has interacted with various suppliers, and the same is accumulated under GSTR 2A. GSTR 3B at this instance is a form that the appellant company, that is the purchaser, has filed to claim input tax credit by stating that they have entered into certain transactions in a particular year for which GST has been collected from them, and on the credit they are claiming a refund, that is on the credit that has been made to the books of the government or the books of the revenue, an ITC is being claimed, is precisely for the purpose for which GSTR 3B is filed by the purchasing company, Your Lordship. Your Lordship, at this juncture the counsel would like to clarify that ITC is a statutory benefit and not an absolute right, contrary to what the counsels for the appellant had previously stated. It is a benefit that the statute gives and therefore can be conditional and can come with its own stipulations. The stipulations here were that under section 16 the stipulations have been detailed, and one particular stipulation is that the government must have a credit in its account to the extent of the GST that they are claiming to have paid, and it is upon this particular credit that ITC is granted.
Section 16 subsection 2 clause AA is effective from which date?
Your Lordship, if the counsel may take a moment to refer to the provision.
Please. It is effective from 1st of January 2022. Where is the researcher? Can't you help him to get?
The same has been denoted in appendix in flag A.
Is the date right? 1st January 2022?
Indeed, Your Lordship.
Okay. What is the financial year for which you are?
1819.
18. Is it applicable?
Your Lordship, under clause under provision C as well, it has been stated that the tax charged in respect of such supply has actually been paid to the government, Your Lordship. Moreover, at this juncture,
No, applicability. The date, effective date
of provision AA, Your Lordship, but subsequently in C also it has been mentioned that Your Lordship, the nature of this ITC in itself is that there is a credit made to the
explain the nature, just tell us whether it is applicable or not.
Your Lordship, clause AA is with effect only from January 2022, and therefore the effect takes place only thereon after. Your Lordship, but in clause C of the same provision, it's been stated that the tax charged must have actually been paid to the government either in cash or through utilization of ITC, Your Lordship.
No, this is regarding matching 2A.
Indeed.
This is what you are arguing, right? When that was not effective for that particular year on hand, how can you argue on that point?
Your Lordship, GSTR 2A at this instance is used to prove in fact that such transactions had been entered into and GST has been collected duly from the purchaser, Your Lordship.
No, it is a facilitation tool by the CBIT. That's all.
Form. They have
That's
given
all.
their invoices, their everything, all the documents they have given. Proof of actual supply they have given. GSTR 2A is a form that is required by you to be filled up, auto-populated on the.
Indeed, Your Lordship, which is the respondent here does not deny that GSTR does not say that GSTR 2A is the only possible means of proof. The council is aware that there are other possible means, but the council like to redirect to Ecom Gill Coffee, the case that was posed before the appellant in itself, where it has been clearly stated that where alternative proof is in fact allowed, mere checks and invoices will not be sufficient, not amount to alternative proof, Your Lordship. The burden of proof under 155 again.
What else do you want?
Your Lordship, the appellant has to prove that GST has in fact been paid out of their hand, and further the nature of input tax credit, that is the benefit that they are in fact claiming in itself, comes directly from the fact that there is a credit in the books of accounts of the government, which there is no proof thereof. There is no proof to say that.
Again, you are circling back to clause AA, which is in force only from January 22.
Your Lordship, there is nothing to prove at this extent that the suppliers have in fact paid such collected GST to the government, Your Lordship. Input tax credit means that it's returned upon collection of something. The unjust enrichment that the appellants claim that the revenue is making at this juncture is false in its entirety, because there has been no.
Counsel, does it not make sense to go to behind the person who is retaining your money? Do you accept the fact that the supplier is the one who has retained the money? Are you not empowered to go behind the supplier?
Your Lordship, the counsel would like to take 2 minutes additionally.
Yes.
Your Lordship, the department here, firstly would like to say that collection of GST from the appellant has not been sufficiently proved, and subsequently there is a possibility that the supplier has not paid, Your Lordship. At this instance, though the department holds the right to take proceedings against the supplier, it does not repudiate the right to conduct proceedings against the appellant in itself.
That is only from 1/1/2022.
Your Lordship, here in the same provision has been brought in the interest of in furtherance of the objective of the legislation, which was never in dispute. It's simply it's clarified to that particular extent, Your Lordship. In the Suncraft case, like the appellants had stated, there is a question of whether litigation has been taken forward against the supplier. The facts remain silent as still the same, and therefore it can neither be assumed that such litigation has been taken nor has been failed.
You tell us now, if you are ready to go behind the supplier, we will give you that liberty.
Indeed, Your Lordship, but that does not deny opportunity for us to litigate against the appellant in its entirety. Those suppliers, Your Lordship, those suppliers may be chased after, it does not deny us in its entirety to go after the appellant. Your Lordship, the reason for...
Imagine you issue notice to supplier also, because he is also a dealer with your registration. You got right to go against supplier or the purchaser. Can you recover tax from both of them? Or will you exempt anyone?
Indeed not, Your Lordship.
Who is first, who is second?
Your Lordship, at this instance, denial of the claim does not result in collection of tax from two persons. Here, collection of tax, the chasing after the supplier at this instance is for actual collection of tax, the credit that is in question. Until such credit is made, the department is not liable to pay any, is not liable to give a benefit to the appellant at this juncture.
Wait a minute, what authority the supplier is going to retain the tax, collect tax?
Your Lordship, the council is unaware.
Levy is on the purchaser.
Indeed, Your Lordship.
Collection authority is retained by the statute with the supplier.
Indeed, Your Lordship.
So now, because of your statutory compulsion, the purchaser pays tax to retains they pay taxes to the supplier. Supplier is your registered dealer, registered person. If he commits default, what is the fault of the purchaser?
Your Lordship, the council...
Is it not your scheme of act is incomplete?
Your Lordship, the council would like to refer to the case of Asta Enterprises, which is mentioned in our memorial as well as our compendiums, wherein if for the convenience of the bench, the council may read the extract that the council is relying upon, Your Lordship.
Yes.
The contention of double taxation does not impress us, especially since the claim is denied only when the supplier who collected tax from the purchaser fails to pay to the government. Taxation as has been held is a compulsory extraction made for the purpose of public good by the welfare state, and without levy being paid to the government, there can be no claim raised of the liability to tax having been satisfied, and hence there is no question of double taxation. Further, it states that, however, as long as the tax paid by the purchaser to the supplier is not paid up to the government by the supplier, the purchaser cannot raise a claim of input tax credit under the statute. We have to notice the word input tax credit itself postulates a situation where the purchasing dealer has a credit in the ledger account maintained by the government, and the said credit can only arise when the supplier pays up the tax collected for the purchaser. Your Lordship, at a later instance, the department will nowhere collect GST again from the purchaser, from the appellant, and they will not be taxed twice, which is a wrongful understanding.
From the appellant is okay. What if you go and collect from the supplier? Because you have powers under the Act to go after the supplier, isn't it?
Indeed, Your Lordship.
And if you pass an order and you collect the tax, you had to have collected tax twice. That's the double taxation.
Indeed not, Your Lordship. The council will the department will duly collect from the same if there is a positive litigation that is taken against the supplier. But at the juncture, the appellant still holds the...
If you have not taken any steps against the supplier, why should the purchaser be, held responsible?
Your Lordship, upon actual credit in the books of the government, the appellant retains the right to claim that tax credit at that juncture. There will be a severe change in the facts that have led to the particular decision against the appellant.
Is it not section 16 arbitrary, one-sided, and mechanical failure?
Indeed not, Your Lordship. The section 16 here simply sets a standard for proof that needs to be fulfilled, and the standard is high simply to ensure that for the benefit of the SSA, the procedure or the interest of public good, which is directly entailed taxation, is not compromised, Your Lordship.
Even the purchaser to be aware, is there any mechanism where he can verify whether the supplying dealer is a tax compliant or not?
Your Lordship, the appellant...
Whether have you notified somewhere saying that he has not collected GST, has not paid it, so he is a doubtful businessman, don't do business with
Your
them.
Lordship, neither has the appellant proved...
Where is the mechanism for the purchaser to verify all these details? Is it not too much, expecting too much from the supplier?
Your Lordship,
and he pay tax,
Your Lordship,
and he suffers denial of input tax credit, and somebody will enrich on that, and you support the defaulter and chases the taxpayer.
Your Lordship, the council like to differ by saying that there is no enrichment here. The department has failed to receive any GST at all, which is precisely...
Like at the time of giving GST registration, you collected the photograph, signature, address, and address is latitude and longitude, lease agreement, and consent from the owner of the property, Aadhaar, PAN. Aadhaar includes biometric. When you have so much of documents to cross-verify the dealer, what prevents you from recovering from the supplier who is a defaulter here? You know that he is a defaulter because the purchaser has given you a tax invoice and tax he has paid. You want to go against him, you want to punish an honest fellow, you want to let go a dishonest fellow. Is this the intention of law or the rules?
Indeed not, Your Lordship. The council is well aware that litigating processes may take place against the supplier as well, but reinstating that it does not deny the opportunity for the department to continue proceedings against the appellant. Your Lordship, with regards to the previous question that the bench had posed, it is also well stipulated that, Your Lordship, 30 seconds to sum up, and the council will move on to prayer.
Please sum up.
Indeed, Your Lordship. Your Lordship, GSTR 2A, though automated, is in the name of the appellant. So at the very instance that GSTR 2A is done, the appellant is given an opportunity to contact the supplier and rectify any errors that may be made thereof. In the instant that those rectifications are still not viable, the law provides for other documents to be submitted as proof to the extent that there has been actual collection of GST from the hands of the purchaser, which in itself has not been proven. Further, the nature of input tax credit in itself, which the appellant is well aware of, the nature of the benefit that they are claiming, which the appellant is well aware of, is reliant upon the fact that there is a credit that is contrary to the transaction that they are claiming. There is a credit in the books of government. To the extent where that is absent and proof has not been fully submitted by the appellant to state that there has been entire collection of GST from the hands of the purchaser, the present issue fails, the contentions made by the appellant fails, Your Lordship. Your Lordship, if the bench is satisfied, the council like to proceed with the prayer. Wherefore, in the light of facts presented, issues raised, arguments advanced, and authorities cited, it is humbly prayed that this Honorable Supreme Court may be pleased to declare that the notification in question is not ultra vires of section 168A, that the impugned order passed by the department is not barred by limitation, adjudge that the non-reparation of foreign exchange within the stipulated time would result in the denial of export incentives, and hold that the non-mentioning of ITC would deny the same in the hands of the purchaser, and pass any other order that this court may deem fit in the proper interest of justice, equity, and good conscience. And for this act of kindness, the respondent shall forever humbly. It has been an honor to argue before this bench.
Your Lordships, the Council shall provide a issue-wise rebuttal for all the issues. The Council shall first address the rebuttals, the submissions made by the my learned friends from the respondent sides with respect to issue 1 and 2.
You are Mr. Harsha, is it?
Your Lordship,
Akshay.
Your Lordships, first with respect to GST Council recommendation. Your Lordships, the very purpose, the legislative intent of mentioning on the recommendation of the GST Council in 168 subsection 1 is to ensure that the central government does not go on a bandwagon to unilaterally issue notifications. My lords, the very nature of the taxation system in India is federal, my lords. The precise reason as to why the recommendation of the GST Council is required to ensure that the interest of all the stakeholders, the states, my lords, the center are duly fulfilled. The central government is not the only stakeholder, and by the act of issuing notification 56 without consulting the GST Council, your Lordships, is a clear attack on federalism. And my lords, today we appear on behalf of appellants to claim from your Lordships' wisdom to hold it an arbitrary act and ultra vires of the section 168, my lords. Secondly, my lords, if even Madras High Court, in the case of Tata Play mentioned, I shall read the verbatim, your Lordships, quote unquote, it was made clear that the recommendation of the GST Council would be binding on the government when it exercises its power to notify secondary legislation. The relevant portion of the Mohit minerals, which my learned friend mentions, was held irrelevant for the current purposes, my lords. Now, your Lordships, coming to the fact that it is a held principle, my lords, that delegated legislation cannot take away a power, cannot take away concession or a right given by the statute, which is in the present matter ITC, my lords. Now, your Lordships, what is also into consideration is the force majeure. Your Lordships, force majeure, as your Lordships are aware, in legal jurisprudence deals with impossibility, not difficulty. Your Lordships, in 2023, the department was functioning. We agree, my lords, there was indeed backlog of cases and piling up of the cases. However, force majeure conditions is taken only when it is exceptionally impossible to do an act. It was difficult, my lords, but not impossible at the time of 2023. As my learned friend has already mentioned, COVID had already subsided. The departmental functioning was into play, my lords. Now, your Lordships, furthermore, my learned friend misleaded the honorable bench by saying we did not reply to the show cause notices. My lords, it was the intimation to which we did not file. And my lords, which even does not hold ground, because we did answer to the show cause notice, and the respondent still does not have the reply as to why our right to ITC should not be denied. Now, my lords, coming with respects to issue 3 and 4. Your Lordships, my learned friend mentioned 2 foreign cases without mentioning which country they were from. My lords, in a very specific case.
Are they reliable case laws, first of all?
My lords, since we do not know it is not provided to us what case laws they refer to. My lords,
because of the AI, we just don't want to be carried away by whatever the councils cite.
Your Lordships, the very nature of the Indian taxation, as we are aware, is very peculiar, and using another country's taxation system into case laws without telling the facts of the case, my lords, is clearly irrelevant. And even my learned friend mentioned the best efforts should be, my lords, advanced. Your Lordships, does sending the emails, does communication channels, does sending communications to the buyer not raise, my lords? We get it. We went a step further, contacted the Indian consulates. Indian consulates tried to do what they could do. My lords, agency of the government, we asked to the agency, we have a problem, couldn't give us the solution. My lords, we even considered litigation, but to commercial reasons, my lords couldn't. And these are the reasons which RBI in its master direction mentions are reasonable. Since reasonable is not even defined by the respondents' council, my lords, we should go by what is here and already provided. And what is provided, my lords, it's given in the compendium. Now, your lordships, furthermore, it is important to state that circular number 183, if your lordships may kindly refer to the compendium, I shall also provide what it means, my lords. It clearly mentioned that in case where GSTR1 is not filed by the supplier, it is to be checked whether A, B and D are fulfilled, which your lordships have already proved to your lordship's satisfaction was indeed satisfied, my lords. The delivery of the goods and services, the time of the payment, my lords, invoices, the bank statements, my lords. Together, all these arguments, none of them were rebutted by my learned friends, my lords. Now, your lordships, furthermore, the council would like to end the rebuttals by saying, my lords, 15 seconds. I was appalled by the fact that my learned friend does not even recognize the need to go after the supplier. They were very much happy with the respondent, the GST department not going after the supplier, and they are denying our rightful ITC wherein we have fulfilled all the statutory obligations, but fails to even consider that they have an obligation, let alone agreeing that okay, we'll do that. Well, it was a clear lack of insincerity on parts of my lords, coming to the Supreme Court and my lords, misleading the bench is not something your lordships prefer. My lords, it was a pleasure arguing before the honorable bench. Much obliged to you.
There's no procedure for reply to reply. Yes, you have 2 minutes.
Your Lordship, the council would take these 2 minutes simply to address the points in order as the councils for the appellant have detailed. Firstly, with regards to the 168A and the notification itself. Your Lordship, reiterating the point that my co-counsel had made, there is a concept of deemed fiction. That is the time that has actually been provided due to facts and circumstances, including force majeure. There is no opportunity for the department to fully utilize such a time, and therefore there is a fictitious assumption of time that has been granted here, which is precisely why the notification has been granted. And 9/2023, there has been sufficient recommendation that has been taken by the council. Though it states that no further extension will be given, the intention of the GST council is clear that sufficient time needs to be provided for the departmental procedure to be complied with. In the interest of the SSC, procedure need not be entirely set aside, your Lordship. And further on the same, as an extension to the same, 56/2023 was brought about, and if the council had any disputes to the same, the council had all the power and authority to deny. Instead, the council has ratified the same as is in this particular instance, your Lordship. Your Lordship, the council has referred to the terms difficulties and impossibilities, stating that there were only difficulties and not impossibilities in this particular instance, your Lordship. The difficulties that were faced due to the direct impact of COVID-19 in this instance was the lack of personnel, the lack of, as members of the bench themselves have pointed out, lack of connectivity. There was several instances where difficulties were faced. These difficulties have led to a direct impossibility to adhere to the timelines in questions, which is precisely why 168A has been utilized. Your Lordship, the council raised questions as to validity of the cases that we have provided. None of these cases we have relied upon the facts. If the councils require, we will entail the same. But the reasons for which we have relied upon these foreign judgments is simply to detail the ambit of interpretation of a term, which is why we have relied on international jurisprudence, and therefore the facts of this case, the cases that we have cited remain without context where the matter is concerned. Your Lordship, they have brought into the light CBIC notification 183. 183 provides for alternative means, which through our course of arguments we have reiterated and time and again to say that on merit they have not been complied with. Your Lordship, the council would like to clarify once again that the council is not denying that litigation can be taken against the supplier, which seems to be the misconception that the councils for the appellant have understood. We are not denying that there is litigating opportunity against the suppliers. We are simply stating that the facts are silent is same, that does
not litigating opportunity, your right to
Indeed, Your Lordship.
right to
In fact, the councils have said that it is our duty to chase the suppliers, which we agree, but that does not deny our right to go after the appellant in this case, which is something the council would like to reiterate again at this particular instance, Your Lordship. If the bench is satisfied, the council like to return.
Reserved, decision reserved.
Hello.
National Corporate Law Moot Court Competition and Judgment Writing Competition of 2026. Over the past few days, we have witnessed exceptional adequacy, sharp legal reasoning, and a true celebration of legal intellect. Today, we gather to formally conclude this remarkable journey and celebrate excellence and learning. To begin this auspicious occasion, I invite Kumari Likita to invoke the blessings of the Almighty.
ಕೋಟಿ ಕೋಟಿ ಕೈ ಮುಗಿದು ಬೇಡುತ್ತಿರುವೆ ಕರುಣಾಕರ ಲೋಕರಕ್ಷಕ ಹೇ ವಿಘ್ನೇಶ್ವರ ಕೈ ಮುಗಿದು ಬೇಡುತ್ತಿರುವೆ ಕರುಣಾಕರ ಲೋಕರಕ್ಷಕ ಹೇ ವಿಘ್ನೇಶ್ವರ ನಮ್ಮ ಎದೆಯಲಿ ನಮ್ಮ ಮನದಲ್ಲಿ ನಮ್ಮ ಎದೆಯಲಿ ಮನದಲ್ಲಿ ಗಣಪತಿ ಗಣಪತಿ ಸದಾ ನೀ ನಮ್ಮನ್ನು ಹರಸುತ್ತಾ ಬಾ ಸದಾ ನೀ ನಮ್ಮನ್ನು ಹರಸುತ್ತಾ ಬಾ 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 ಕೋಟಿ ಕೋಟಿ ನಮನ ನಿನಗೆ ಮಹಾಗಣಪತಿ ಲಕ್ಷ ಲಕ್ಷ ದೀಪಾರ್ಚನೆ ದಿವ್ಯ ಗಣಪತಿ महागणपति दिव्य गणपति महागणपति महागणपति महागणपति. Thank you.
Thank you, Likita, for the soulful invocation. To formally welcome our distinguished gathering and introduce the guest for the day, I now invite Dr. N. Vanishri, Principal, JSS Law College, to deliver the welcome address.
Seeking the blessings of His Holiness Swamiji, very good evening to the ladies and gentlemen. After days of intense legal debates, scholarly research and passionate advocacy, we arrive at the culmination at the 23rd Surana and JSS Law College Corporate Law Moot Competition and Judgment Writing Competition 2026. Before we proceed with the main event, let us formally welcome our dignitaries and the esteemed guests for this evening. We are profoundly honored to have with us today the legal luminary who exemplifies legal excellence and ethical leadership, our chief guest, Honorable Mr. Justice K.V. Arvind Sir, Judge, High Court of Karnataka. Sir, your presence is a true source of inspiration for these young legal minds, and thank you for your time, attention and thoughtful consideration. We look forward to your address and motivation which will spark in every young mind present here. A very warm welcome to you, sir. We are also honored by the presence in our midst of the guest of honor, Shri T. Surya Narayana, Senior Advocate, Bengaluru, who has kindly consented to be with us this evening for the valedictory program. A very warm welcome to you too, sir. I take immense pleasure in welcoming Srimati V. Manjula, Assistant Commissioner, to this valedictory ceremony. Ma'am, welcome to you too. I extend my cordial welcome to our gracious Chief Executive, Professor K. S. Suresh, on this occasion. Sir, warm welcome to you, sir. We extend a cordial and affectionate welcome to Shri Preetham Surana, Partner Dispute Resolution and Head, Academic Initiatives, Surana and Surana International Attorneys, Chennai, to this program. A warm welcome to Achyuta Sir, and with utmost respect, all the judges, including our advocates, our alumni who are with us here, chartered accountants and the company secretaries who have judged this competition and played a very significant role in this event. I extend a very warm welcome to Shri A.D. Johnson Christie Sir, Manager Special Projects, Academic Initiatives, for his untiring efforts. A hearty welcome to Shri Karthik Ranganathan. I welcome the JSS Moot Court Society Coordinator, Dr. Jagdish, and the convener of this event. In advance, congratulations to all the participants and a warm welcome to you. Your dedication and hard work have truly paid off. You are all winners for taking off this challenge and demonstrating such passion for the law. I heartily welcome all the participants from across the nation. A warm welcome to the press who have assembled here in large numbers for the coverage of this event. A warm welcome to the teaching and non-teaching staff of the college, and of course to our volunteers who have tirelessly worked for the success of this competition. As we draw the curtain on this memorable event, we must acknowledge the relentless efforts of everyone who have made this competition a grand success. And as we conclude, let the spirit of justice, integrity and pursuit that fueled this competition continue to guide all of us, and especially the youngsters who are sitting right in front of us. A very warm welcome once again to one and all. Thank you very much.
Thank you, ma'am. I extend a warm welcome to you too. I now invite Shri Preetham Surana, Partner Dispute Resolution and Head Academic Initiatives at Surana and Surana International Attorneys, to deliver the special address.
My cordial compliments to members of the dais, Honorable Mr. Justice K.V. Arvind, Judge High Court of Karnataka, Shri T. Suryanarayan, Senior Advocate, Bengaluru, Srimati V. Manjula, Assistant Commissioner, Mysore Audit Commissionerate, Mr. Professor K.S. Suresh, Chief Executive, JSS Law College, Mysuru, Dr. N. Vanishri, Principal, JSS Law College, Mysuru. I would, Mr. C.G. Betsurmat, Executive Secretary in absentia. I would like to acknowledge the presence of Mr. Shashidhar, Superintendent, Mysore Audit Commissionerate. Thank you for being with us, sir. Mr. Karthik Ranganathan, Mr. CA, Mr. Achutan, practitioners, professionals, respected faculty members, faculty conveners, Moot Court committee members, members of the press, students of this law college, and my dear participants. It is a privilege again to represent our firm before you, and it's a very nice feeling to be back again. It's become an annual ritual at JSS, and I stand before you, I think some of the sharpest legal minds, if I may say so. There is something which I want to touch upon today, which is it is something which we must talk about, and I thought it fit, and that is nothing but what we do, we have started doing every day, is use of artificial intelligence. What really keeps me thinking is whether the young minds entering today are so slowly surrendering themselves to AI. AI is a reality, and let me tell you, law firms are using AI, whether it's contract review at scale, automated due diligence, first draft generation, litigation outcome prediction, etc. So what has happened is that tasks that trained young lawyers are now being absorbed by systems. So the uncomfortable question is, what happens to training when the training ground disappears? So if you remove the grind, you lose or you risk removing the growth. The late nights wrestling with a difficult judgment was not punishment, but they were cognitive conditioning of our minds. Cognitive conditioning is, of course, a very important part for professionals from the legal fraternity. That itself is a separate subject which we will probably talk sometimes else, but I will stick on to AI for now. So the danger is not AI, but the danger is something quieter and more insidious, and that is our intellectual dependence on AI. The slow, bearable erosion of our reasoning sharpness over time, not occasionally, not selectively, but systematically. Courts, of course, have embraced digitization with remarkable speed, and whether it's e-filing, virtual hearings, data-driven case management, etc. And it is genuine to be admiring this, but I also say that with clarity that efficiency is not adjudication, digitization is not justice. They serve justice, they are not a substitute to it. The Supreme Court itself has recently referred AI tools in open court, and they thought it important to clarify this, that we do not consider them as authoritative sources of law, So this clarification was not incidental, it was important because of the submissions that have come before the court, before the apex court. So the moment we mistake assistance for authority, we begin to compromise the very structure of judicial reasoning. Law in India is doctrine driven, shaped, contested and refined every single time it is put to test in a court. The reasoning behind any significant judgment cannot be reduced to computation of past patterns, because law is not trying to correct the past. AI is trained on the past to predict the future. So these are different, fundamentally different enterprises, and we must never confuse them. Lawyers do not merely apply the law, we question law, its legality, its constitutionality, its underlying morality, and that requires conscience. So the real impact of human intelligence is on technology, will not be technological, it will be psychological. When answers are instant, patients shrink. When research is automated, depth declines. When drafting is assisted, originality weakens. The brain left to its own devices will always optimize for ease. But the law at every level that matters rewards endurance. The best advocates I have encountered were not the fastest thinkers in the room, they were the most resistant ones. Resistant to easy conclusions, resistant to comfortable consensus, resistant to the seductive pull.
I congratulate JSS Law College, Surana and Surana International Attorneys and the faculty of JSS Law College for organizing this corporate law moot court competition and for extending an invaluable opportunity to law students to exhibit their excellence. Having had the privilege of sitting on the panel for the final round, I must begin by congratulating both teams for high standard of advocacy displayed today. The preparation, composure and clarity with which you presented your submissions reflect the seriousness, dedication and hard work with which you approached this competition. I also congratulate all the participants who have earned the opportunity to be here. I am pressing that you have earned this opportunity because no one will give you an opportunity. You have to earn opportunities for yourself. I firmly believe that the opportunities are not merely given, they are earned through effort, preparation, and continuous hard work. Your presence here is a reflection of that commitment and merit. Moot court competitions form an integral part of legal education. A moot court is in many ways the first exposure to the culture and discipline of courtroom. It instills discipline, humility, and healthy spirit of competition in young minds preparing to embark upon the legal profession. A moot court is not merely a contest, it is a training ground. It demands research, structured thinking, teamwork, time management, and the courage to stand and defend a proposition of law with clarity and composure. The real courtroom environment may indeed differ from the moot court. A moot court is conducted in a guided academic settings where errors become opportunities for correction and growth. In contrast, proceedings in a court of law involves real litigants, real rights, and real consequences. Yes, it is in this structured environment of mooting that you are trained to shoulder future responsibilities with confidence and maturity. Mooting teaches lessons beyond textbooks, statutory provisions, and classroom instructions. It deepens one's understanding of legal principles and refines the art of advocacy. It prepares you for the profession even before formal entry into it. The legal profession has undergone a remarkable transformation over the years. There was a time when the law was often chosen as a career only when other avenues seemed unavailable. That era has passed. Today, owing to the vast scope, opportunities, and significance of profession, law is increasingly considered a first preference. The profession is no longer confined to traditional litigation or conventional practice. With the advent of modern technology and artificial intelligence, legal professionals now have access to a wide array of tools that assist in research, drafting case analysis, and strategy. At the same time, these advancements have introduced new complexities and diverse challenges. In earlier times, a litigant would approach a legal practitioner solely with a problem, seeking advice and a solution. Today, with increased technological access, legal awareness, and the widespread availability of information, the approach of the litigant has significantly changed. A litigant often comes not only with a problem, but with multiple solutions, seeking validation or approval from the legal professional. This is one of the major challenges of the present. Lawyers today must be not only knowledgeable, but also discerning, adaptable, and technologically equipped. The students here who are at the threshold of entering this noble profession must be prepared to face these challenges. Oral advocacy alone is no longer sufficient. It is equally important to deep technological skills and adaptability, a change in approach, a change in thinking, a change in attitude, and even a change in behavior to suit present realities are all necessary in today's legal profession. Participation in unique programs and competitions such as this helps in developing these essential skills. The objective of proper participation need not be limited to winning. It is equally, if not more, valuable as a learning experience. Every participant may not leave this hall with a medal, but each one will certainly leave with added knowledge, richer experience, and greater confidence. If I may say a few words about the problem selected for the final round of this moot court competition, that is tax law, specifically on GST, a branch of law which, in my view, offers immense, promising, and significant professional opportunities. From my experience, I have observed reluctance among young lawyers to take up practice of tax law. That hesitation may be with the impression that tax practice demands specialized knowledge, particularly in accounting and finance. No doubt such knowledge is required. However, expertise is not acquired overnight. It is gained gradually through sustained learning and practical experience. Young lawyers should not always seek immediate courtroom exposure or expect quick results. As a student, one may be accustomed to quick outcomes and immediate solutions. But the legal profession does not offer shortcuts. It does not promise instant success. What it demands is constant, dedicated, and disciplined effort over time. The initial years of practice may test your patience. There may be days when you are not heard, when your role is limited, or when progress seems slow. Yet those years are not empty. They are formative. They teach you how courts function, how arguments are built, and how the law is applied in real-time situation. They shape your understanding, strengthen your resilience, and lay the foundation for the advocate you will be eventually become. The first and foremost quality required in law is curiosity. A good law professional does not merely accept the law as it is. He or she constantly asks, why is the law so? What is its purpose? What mischief does it seek to remedy? It is this spirit of inquiry that transforms mere learning into a real understanding. Discipline in profession is equally important. Research is what gives a lawyer confidence in court. When you stand before the bench, it is not merely your words that speak, it is the preparation behind those words. A well-prepared lawyer argues with clarity, responds with precision, and assists the court effectively. To be a good lawyer, the ability to simplify complexity, both for the court and for the client, is important. Precision in language, structure in argument, and brevity in presentation are qualities that must be cultivated from the beginning. The legal profession is often described as a noble profession, and rightly so. Apart from legal acumen and advocacy skills, it is equally important for every legal professional to maintain exemplary conduct, both inside and outside the courtroom. The legal profession is no longer merely a means of livelihood, it is a responsibility towards society. A lawyer becomes the voice of the voiceless and is entrusted with the duty of safeguarding constitutional and legal rights before the court. As an advocate, while you must diligently protect the interest of your client, you also owe an equal important duty to the institution. For you or an officer of the court, it is necessary to uphold and preserve the institutional integrity of the judiciary, even while fearlessly defending the cause entrusted to you. Above all, the legal profession is built on trust, the trust of the client, the trust of the court, and trust of the society. No amount of skill, intelligence, or eloquence can substitute for credibility. Therefore, while choosing your area of practice, do not be guided merely by popularity or immediate visibility. Consider fields like tax law, which may appear challenging at the outset, but offer immense scope for growth, intellectual satisfaction, and long-term professional stability. The success in law do not belong only to the talented, but to the most disciplined, the most curious, and the most persistent. I once again congratulate JSS Law College, Surana and Surana International Attorneys, and the participants for this event. I thank JSS Law College for giving me this opportunity to share a few thoughts with the students. I wish each one of you success and a meaningful, principled, and fulfilling career ahead. Thank you. Jai Hind.
Thank you, Your Lordship, for your profound and inspiring address. Your words will certainly leave a lasting impact on all of us. I now invite our Chief Guest of Honor, Shri D. Suranarayana, Senior Advocate, Bengaluru, to address the gathering.
Honorable Justice K.V. Arvind, Manjula ma'am, Vanishri ma'am, Professor K.S. Suresh, Mr. Preetham Surana, my friend Mr. Ranganathan, and the person who came to Bangalore thrice, I think, to invite me, I should, thank Dr. Jagdish for traveling all the way to Bangalore and, I must compliment Surana and Surana one of the oldest law firms, who's also a pioneer, who has taken up this task as a social responsibility, to promote moot courts, to bridge the gap between legal education and practice, because there's a lot of gap between what you study in colleges and what litigation practice is once you step into court. So moot court basically does that, and Surana has been pioneer in that. They have been doing that for the last 30 years across the country and beyond. I must also compliment JSS Law College, which is one of the oldest autonomous law colleges, or the first autonomous law colleges in India. It has been nurturing talent in legal field for so many years. We have so many colleagues at the bar from JSS Law College. So many of their alumni are now judges, and one such eminent alumni is sitting right in front of us, who has practiced both on the revenue side, now is on the SSE side, and who's been also very deeply involved with organizing and taking this moot court competition, Surana and Surana JSS Law College moot court competition forward for the last 12-13 years, I am sure. So as far as the young, aspiring, bright, legal eagles, if I may call you all, the advice I give you, Dr. Jagdish said you should speak and give some advice to all the youngsters. From my own experience, I have seen Justice Arvind also very closely, like he mentioned, we actually started practice together in the year 2000 under two very senior, his senior Mr. Seshachala, who's now a senior advocate, my senior Mr. K.B. Kumar, who's also a senior advocate. Of course, on different sides, he was practicing on the revenue side and I was on the SC side. From our own experiences, the advice that I can give you is, first thing, don't run after money. Make money run after you. Now, how do you do that? How do you make money run after you? Once you get out of college, don't think about money. The first thing you should choose is a good office to practice in. Of course, as a law student, you will be under a dilemma whether to go for corporate, or litigation. My advice as a practicing, you may think I'm biased towards litigation, but I'm not. Even if you want to choose corporate, some amount of litigation practice, court practice is necessary, is what I feel. Even if you want to tomorrow do just transaction work, M&A work, which does not involve going to courts, which involves just drafting of contracts or negotiating contracts and so on and so forth. Even for that, you need that 3, 4, 5 years of court practice. So first advice is that you should all try to, as soon as you get out of college, unless of course you are immediately going for a higher, a master's, obtaining a master's degree or something, you should all practice litigation for some time before deciding which course you will take, whether it is litigation or non-litigation. Then you choose a good office which gives you exposure to, it could be a firm, it could be an individual lawyer. Don't join companies directly, because even if you want to join companies as general counsel, first you require that court experience. So pick a good office, a firm or an individual lawyer who has a diverse practice in diverse areas, civil law, some amount of criminal law, some tax law, some corporate law, because that gives you, of course, compared to our days, you have a 5-year, I did a 3-year course, I think, I'm not sure about the others, but you are all in the 5-year integrated course, so you have some exposure by way of internships in various branches of law. But that practicing in an office or with a junior, with a senior who has a diverse practice makes you choose ultimately which area you want to specialize in, because these are days of specialization. These are not days, olden days, where one single lawyer used to handle all kinds of work. These are, now there's more competition, more number of law colleges, more number of students coming out of law colleges. There's immense competition. So these are days of specialization. A client looks to go to a tax lawyer, looks to go to a IP lawyer, looks to go to a, even in civil law, there are lawyers who specialize in land acquisition, who specialize in service law, who specialize in, motor vehicles, so on and so forth. So when it is days of specialization, you will require that much time basically to decide which area you would like to specialize in. So for that, it is very important that you join an office or where you have a diverse, variety of work, which gives you that exposure and which ultimately makes you decide which area you would like to specialize in. And after doing that, ultimately it's about discipline, hard work, time management. These are these are things that you require in any profession. Without these, you can't expect success. If you have all this, if you do all this, of course, ultimately you may choose not to pursue litigation, but even like Justice Arvind mentioned, it's not as if tax law is very difficult. If you have the basic foundation, if you know the basic principles of tax, although tax changes, like we have, entire indirect tax change in 2017 when GST came in, and now we have studied income tax for the last and practiced income tax for the last 25 years. Now we have to start reading new Income Tax Act from this year. So tax does keep changing, but then if you have your foundation good, if you have a good foundation, if you know the basic principles of tax, what is direct tax, what is indirect tax, what is the charge, what is the rate of tax, what's the, these basic principles, if you are sound in, you can practice tax very easily. It's not a very difficult subject to practice. So all this you will know only when you experience it, isn't it? Because that's why I said you have to choose an office which gives you that exposure to all areas of law, and then you can decide which area you are good at, because you are not everybody is suitable for every area of law. Every area of law requires a different mindset, and for example, criminal law requires a completely different mindset compared to civil law, because you are dealing with crimes and offenses. It requires a different mindset. Not everybody is meant to do criminal law. So you have to basically you get that exposure. That exposure you won't get in law colleges. That exposure doesn't come even with your 1 month internships during your holidays. It doesn't come. It will come only after you step into practice, work for 3, 4, 5 years, depends on how soon or how quickly you grasp and learn, and then you decide your specialization, and ultimately, of course, you want to choose non-litigation. That's, of course, a different thing. So this is my advice to all of you, but I have today, it was very difficult for us to decide, amongst the finalists. They performed exceptionally well, both teams. It was a very tough decision for us to, sit and decide who should win. Ultimately, you'll get to know the results soon. But wishing you all youngsters the very best, and hope to see you all soon at the bar. Thank you all.
Thank you, sir, for the enlightening address. I now request Srimati V. Manjula, our esteemed guest of honor, to address the gathering.
Courtrooms don't just deliver justice. They are there where justice is defined. Good evening to all the distinguished guests. Honorable Justice K.B. Arvind, Sri Satyanarayan, Sri Preetam Surana, Dr. Vani Shri, Achyut sir, and Karthik Ranganathan. Respected faculty members, organizers, and my dear friends.
It is truly an honor to be here today. Being among such eminent personalities is both humbling and inspiring. And I sincerely thank JSS, Law College, and Surana attorneys for inviting me for this. Having just witnessed the final round, I must say the level of preparation, clarity of thought, and confidence displayed by all the participants was immense. Moot court competitions like these are where law truly comes alive. They bridge the gap between what is written in books and how it is practiced in reality. When I look at all of you, I don't just see participants, I see future lawyers of this country, policy makers and judges who will help the legal framework of this country. As Mahatma Gandhi once said, a nation's greatness is measured by how it treats its weakest members. And at its core, that is what law seeks to ensure: fairness, balance, and justice. From my experience as Assistant Commissioner of GST, I have seen firsthand that law is rarely as simple as it is written in books. It evolves through interpretations, discussions, and real-world challenges. The goods and services tax is one of the most significant reforms in India's indirect taxation system. It was introduced to remove this cascading effect of indirect taxes and bring multiple indirect taxes under one head. But what makes GST truly interesting is not that it is replaced, but how it was implemented. Through the 101, that is the 101st Constitution Amendment Act 2016, the Constitution was amended so that both the Parliament and the state legislatures can make laws in GST. This marked a shift from a strictly divided taxation system to one based on cooperative federation. The creation of GST Council under Article 279A further strengthened the idea, bringing together the center and the states to make collective decisions and maintain a harmonized tax structure across the country. We also see, this is reflected in the three heads, that is the CGST, SGST, and IGST. Now, while this framework appears structured, the real challenge lies in interpretation and implementation. GST is still evolving. New issues arise, ambiguities emerge, and interpretations differ. And this is where you all come in. Because in law, clarity is rarely given. It's argued into existence. What we witnessed today in this courtroom reflects that very process: careful analysis, thoughtful interpretations, and the ability to stand by your arguments in confidence. Moot court competitions are not just arguments. They are about learning how to think, how to stay composed under pressure, and how to communicate effectively. As judges, we were not only evaluating your knowledge, but also your clarity of thought, your ability to structure arguments, and how well you responded to questions. And I must say, all the finalists demonstrated exceptionally well. Before I conclude, I would like to leave you with this. This law does not belong only to courtrooms. It belongs to those who have the courage to question it and the skill to interpret it, and a conviction to stand by it. And one day it will be your voice that shapes the law in this country. I would like to extend my heartfelt congratulations to all the finalists and the winners, of course. That doesn't mean that the runners-up didn't do well. They all did extremely well. Let us wait for the final results. Thank you.
Thank you, ma'am, for your valuable thoughts and encouragement. We now invite a few participants to briefly share their experience. I call Mahipal Parmar to share his experience.
Good evening, distinguished judges and honorable guests and member of the bench. I am deeply grateful to the organizing committee for graciously extending this opportunity to addressing such a distinguished gathering. I would like to take this moment to express my sincere appreciation to the organizing committee for their exceptional support, dedication, and seamless coordination that made this event a resounding success. I would also like to acknowledge the legal luminaries present among us whose insights and wisdom have been truly invaluable. The knowledge you have imparted will undoubtedly guide us as we step forward in our legal careers. It has been a genuine honor and a privilege to interact with each one of you. Thank you.
Thank you, Mahipal. I now call upon Srinidhi Mahesh to share her experience.
On behalf of my team and I, we'd like to thank the organizing committee personally. They've been very accommodative of all of our doubts, several doubts that we've asked throughout this competition and several requests that we've made. On the note of feedback, we thoroughly enjoyed the standard of quality that this competition maintained. Not only with regards to the increasing standard of difficulty with regards to judges and how well versed they were, it truly enriched our learning experience. But every opponent that we've contested against from preliminary rounds 1 up until today, they've shown exemplary standard, and through every argument that our opponents have given, we have conveniently used some 1 or 2 points at the minimum that we've learnt at each juncture that we've used in the next round. So we've learnt a lot throughout this competition. We were also asked to give constructive feedback if we had any that we'd like for them to improve. Personally, just considering our team, on one day 4 rounds was personally very exhausting for us. So if there's any means for you to distribute the number of rounds per day, we'd be very grateful as a team. So thank you once again for this opportunity.
Thank you, Srinidhi. I now call upon Tulsi Mayuri to share her experience.
Namaste and good evening. My name is Tulsi Mayuri, a participant from Sharda Vilas Law College, Mysore, Karnataka. Firstly, it's my honor to stand before you and all the dignitaries to share my experience. First, I need to thank Sir Preetham Surana for conducting this corporate law moot court for the 23rd year, sir. I also pray that God give you enough strength to carry this for next 100 years, sir. Thank you so much, sir. And secondly, I shall thank Ma'am Srimati Vanishri Ma'am, the principal of this JSS Law College. That Ma'am, thank you personally. Thank you so much for inviting Sharda Vilas Law College, ma'am. Thank you so much, ma'am. Now I shall say the best thing about JSS Law College is that they have such a good eyes selecting the judges that during our preliminary rounds I have done many national moot courts, but the judges are really hasty while asking questions during the preliminary rounds, and they won't let us complete our arguments. But this time in international moot court, they were so professional, they were so like calm and composed that they let us complete our arguments and then ask questions. So thank you so much for the respected judges, sir. Because of you guys, my team, Sharda Vilas Law College team, Neetu as researcher, Maria Jennifer and me got qualified for octa finals. Thank you so much. And now talking about the food was very good actually. The refreshment served was actually refreshing. And the college didn't get themselves stick for only serving the South Indian food. They also did serve us North Indian food, which we really enjoyed as South Indians. Thank you so much for serving very tasty food. Okay, now if I don't know if there is this winning for escort team, best winning team, but I shall thank Sanjana SB as my personal escort. If there was award, it would go to you, Sanjana. Thank you so much for being my personal escort. Now I shall also thank Adarsh Shakti for giving me this opportunity to present before you all guys. And at conclusion, I want to say that it really takes guts to stand in front of the sitting judge of High Court and do our mooting. But CL number 19 and CL number 17, the finalists, you did very good. And I shall congratulate you and say all the best, guys. I hope you guys did your best, and I must say you guys slayed in your arguments. Thank you so much. Jai Hind.
Thank you for sharing your wonderful experiences. It truly reflects the spirit of this competition. We now proceed to felicitate our distinguished guest as a token of our respect and gratitude. I request Professor K.S. Suresh, Chief Executive JSS Law College, Mysuru, to kindly felicitate Honorable Mr. Justice Thank you, sir. I now request Dr. Jagdish Shetty, Coordinator, Moot Court Society, JSS Law College, Mysuru, to felicitate Shri T. Surya Narayana, Senior Advocate, Bengaluru. I now request Dr. N. Vanishri, Principal JSS Law College, to felicitate Srimati V. Manjula, Assistant Commissioner, Central Tax, Audit Commissionerate, Mysuru. Thank you, ma'am. I now request Professor Shivananda Bharti, Controller of Examination, JSS Law College, to felicitate Shri Preetam Surana, Partner, Dispute Resolution and Head Academic Initiatives, Surana and Surana International Attorneys. Thank you, sir. I now request Honorable Mr. Justice K.V. Arvinda to facilitate Mr. Achyuta, renowned Chartered Accountant. Thank you, Your Lordship. Your Lordship, I would also request you to please felicitate Mr. Karthik Ranganathan, Senior Advocate, Chennai. Thank you, Your Lordship. Last and final request, kindly request you to also felicitate Mr. A.D. Johnson Christie, Manager, Special Projects, Dispute Resolution and Academic Initiatives, Surana and Surana International Attorneys. Thank you, Your Lordship. I now request Dr. Jagdish A.T., Coordinator, Moot Court Society, JSS Law College, Mysuru, to felicitate Professor K.S. Suresh, Chief Executive, JSS Law College, Mysuru. Thank you, sir. Now I request Srimati Usha Rani, Head of Department of Postgraduate Studies in Law, JSS Law College, Mysuru, to felicitate Dr. N. Vanishri, Principal, JSS Law College, Mysuru. Thank you to all our honored guests for gracing this occasion and enriching it with your presence. And now comes the moment everybody has been eagerly waiting for, the announcement of results. I invite Mr. A.D. Johnson Christie, Manager, Special Projects, Dispute Resolution and Academic Initiatives, Surana and Surana International Attorneys, to declare the results of the competition.
Respected Lordship, honorable dignitaries on the dais, faculty members, student coordinators, faculty coordinators of the Moot Court Society, students of the JSS Law College, and my dear participants. It's my honor and privilege to be here to announce the results. Before that, we would want to distribute the participation certificates. So I now request Dr. N. Vanishri, Principal, JSS Law College, and Mr. Preetham Surana to please come forward to distribute the participation certificates. It's a home team from JSS Law College, Disha Solanki, Prithvi S. and Shweta D. A big round of applause for the home team who had actually made it to the advanced rounds. Muruga and Shivanand. CL04 Vaikunta Baliga College of Law, Udupi, Chris Manuel Chettiar, Gayatri Chitresh and Hari Sankaran. Abhinav, Tanisha and Darshini. CL06 BITS Law School, Kalyan, in absentia. They are to travel for the semester exams. CL07 Gujarat National Law University, Gandhinagar, Akansha Kamal, Mahipal Parma and Anya Deharia. CL08 Chennai Dr. Ambedkar Government Law College, Pattarai Perumpudur, Prabhu, Kavya and Surya Prakash. CL09 Anandam Law College, Tanjavur, Sakti, Kalai Selvan and Muruganandan. CL10 Dr. B.R. Ambedkar Law College, Hyderabad, Srinija Telu Kaveri and Sandeep Kumar. Institute of Law, Nirma University, Ahmedabad. Sakshi Ramrakhyani, Mahir Jain and Pratham Khandelwal. The third Best Memorial Award goes to CL19, Dr. Ram Manohar Lohia, National Law University, Lucknow, Akshit Joan, Harshvardhan Singh Bandari and Gurmahek Kaur Chahil. The Best Student Advocate Award is basically based upon your preference, your scores obtained in the preliminary rounds. And the fourth Best Student Advocate Award goes to CL18, Neha Venkatesh Kumar of St. Joseph's College of Law, Bengaluru. The third Best Student Advocate Award goes to CL17, Srinidhi Mahesh of School of Law, Shastra deemed to be University, Tanjavur. Thank you, Madam. I now request Sri T. Surya Narayana, Senior Advocate, Bengaluru, to please come forward to hand over the awards. The team placed fourth in this competition are CL28, University Law College, Bangalore University, Bengaluru, Bharat A.V., Pavan Kalyanji and Nidhi Rao. The second Best Student Advocate Award will also receive a cash prize of rupees 5,000, goes to CL22 Avishruti Singh of National Forensic Sciences University, Gandhinagar. The second Best Memorial Award will also have a cash prize of rupees 5,000, goes to CL13 Symbiosis Law School, Pune, Kavya Chaudhary, Priyanshi Gupta and Savarni Yasharta. The Best Student Advocate Award of this competition would also receive a cash prize of rupees 10,000, goes to CL17 Sagarika Nair of School of Law, Shastra deemed to be University, Tanjavur. The team placed third in this competition are CL27, Institute of Law, Nirma University, Ahmedabad, Sakshi Ramrakhyani, Mahir Jain and Pratham Khandelwal. The Best Memorial Award of this competition will also receive a cash prize of rupees 10,000 goes to CL21 Rajiv Gandhi National Law University, Punjab, Sharda Kachwa, Srijita and Aryan Taluja. Thank you, sir. Honorable Mr. Justice K.V. Arvind, Judge High Court of Karnataka, Professor K. Suresh, Chief Executive, JSS Law College, Mysuru, and Mr. Preetham Surana, Partner Dispute Resolution and Head Academic Initiative, Surana and Surana, to please come forward for the big awards. With the permission of Lordship, shall we go for a countdown? 10, 9, 3, 2, 1, and the winning team are CL17 School of Law, Shastra deemed to be University, Tanjavur. The winning team will also receive a cash prize of rupees 30,000. Goes to Sagarika Nair, Srinidhi Himahesh and Sai Nihant Reddy. The runner-up team is CL19, Dr. Ram Manohar Lohia, National University, Lucknow, Akshit June, Harshvardhan Singh Bandari and Gumahek Kaur Chahil will also receive a cash prize of rupees 15,000. The Best Speaker of Finals Award goes to CL19 Akshit June of Dr. Ram Manohar Lohia, National University, Lucknow. The Spirit of Surana Award. Spirit of Surana Award is symbolized by holistic excellence in camaraderie and performance. The participants in the competition had casted the votes for the team that epitomizes the Surana spirit of excellence of intellect and astuteness in argumentation, spirited and healthy competition, team solidarity, and goodwill and harmony with other teams. The award goes to CL11 BMS College of Law, Bengaluru, Ashika, Anusha, and Karthik Mahita Shigli. They had secured 11 votes. Thank you, Lordship. Thank you, teams. Yes, Surana and Surana Initiative Attorneys, International Attorneys, a special appreciation certificate to the host university to be honored now. I would request Mr. Preetham Surana to please come forward, and Professor K.S. Suresh, Chief Executive, Dr. Vanishri, Principal, Dr. Jagdish, AT Faculty Coordinator, Student Coordinators of the Moot Court Society, Ms. Shashwati, Ms. Ananya, Mr. Rohan Gangadhar, and Chaya and team to please come forward to collect the certificate.
And to every participant, your effort, dedication and adequacy has been commendable. As we approach the conclusion of this memorable evening, I invite Dr. Jagdish A.T., Coordinator, Moot Court Society, JSS Law College, Mysuru, to deliver the vote of thanks.
And Surana and JSS Law College, Corporate Law Moot Court and Judgment Writing Competition 2025-26. I feel deeply honored to deliver this vote of thanks. First and the foremost, I would like to express our profound and heartfelt gratitude to our distinguished chief guest, Honorable Mr. Justice K.V. Arvind, Judge, High Court of Karnataka, Bengaluru. Thank you, sir. I express my deep sense of gratitude to Shri T. Satyanarayana, Senior Advocate, Bengaluru, for judging the finals and addressing our participants. Thank you, sir. I wish to express our sincere thanks and appreciation to Srimati V. Manjula, IRS, Assistant Commissioner, Central Tax, Audit Commissionerate, Mysuru. Thank you, ma'am. Our special thanks to Shri Karthik Ranganathan, Advocate, Chennai, the framer of the problem. Also, I would like to express my heartfelt thanks to Sri Achyuta, Chartered Accountant, Mysore, for judging the finals. Our special thanks to Professor K.S. Suresh, Chief Executive, JSS Law College, and Dr. N. Vanishri for their support and cooperation. Our deepest appreciation to the learned bench, all the judges who have judged from prelims to semi-finals, nearly 35 in number, for sparing their valuable time and for providing us with insights that can only come from their experience. JSS Law College Autonomous, as a team, thank Surana and Surana International Attorneys, Chennai, for partnering to conduct this competition successfully. Our special thanks to Shri Preetham Surana, Partner Dispute Resolution and Head Academic Initiatives, Surana and Surana International Attorneys, Chennai, and Shri A.D. Johnson Christie, Manager, Special Projects, Academic Initiatives and Dispute Resolution Practice, Surana and Surana International Attorneys, Chennai. Next, to all teams, you did not just argue cases, you breathed life into them, demonstrating resilience, passion, and the highest standards of integrity. Thank you, all the participants. Thank you once again. A special acknowledgement to the student committee and volunteers of JSS Law College who worked behind the scenes to ensure that the competition ran seamlessly. Thank you. Also, I would like to thank the media who had turned in large numbers. While the trophies will reside with the winners, the knowledge gained belongs to us all. With this, I once again thank everyone who directly and indirectly supported and cooperated for this success of this event. Thank you one and all.
Thank you, sir. I now request everyone to kindly rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल वंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभाशिष मागे गाहे तव जय गाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
I request all the participants to stay back till the guests leave.
And Surana and JSS Law College Corporate Law Moot Court and Judgment Writing Competition 2025-26. I feel deeply honored to deliver this vote of thanks. First and the foremost, I would like to express our profound and heartfelt gratitude to our distinguished chief guest, Honorable Mr. Justice K.V. Arvind, Judge, High Court of Karnataka, Bengaluru. Thank you, sir. I express my deep sense of gratitude to Shri T. Satyanarayana, Senior Advocate, Bengaluru, for judging the finals and addressing our participants. Thank you, sir. I wish to express our sincere thanks and appreciation to Srimati V. Manjula, IRS, Assistant Commissioner, Central Tax, Audit Commissionerate, Mysuru. Thank you, ma'am. Our special thanks to Shri Karthik Ranganathan, Advocate, Chennai, the framer of the problem. Also, I would like to express my heartfelt thanks to Shri Achyuta, Chartered Accountant, Mysore, for judging the finals. Our special thanks to Professor K.S. Suresh, Chief Executive, JSS Law College, and Dr. N. Vanishri for their support and cooperation. Our deepest appreciation to the learned bench, all the judges who have judged from prelims to semi-finals, nearly 35 in number, for sparing their valuable time and for providing us with insights that can only come from their experience. JSS Law College Autonomous, as a team, thank Surana and Surana International Attorneys, Chennai, for partnering to conduct this competition successfully. Our special thanks to Shri Preetham Surana, Partner Dispute Resolution and Head Academic Initiatives, Surana and Surana International Attorneys, Chennai, and Shri A.D. Johnson Christie, Manager, Special Projects, Academic Initiatives and Dispute Resolution Practice, Surana and Surana International Attorneys, Chennai. Next, to all teams, you did not just argue cases, you breathed life into them, demonstrating resilience, passion, and the highest standards of integrity. Thank you, all the participants. Thank you once again. A special acknowledgement to the student committee and volunteers of JSS Law College who worked behind the scenes to ensure that the competition ran seamlessly. Thank you. Also, I would like to thank the media who had turned in large numbers. While the trophies will reside with the winners, the knowledge gained belongs to us all. With this, I once again thank everyone who directly and indirectly supported and cooperated for this success of this event. Thank you one and all.
Thank you, sir. I now request everyone to kindly rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल वंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभाशिष मागे गाहे तव जय गाता जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
I request all the participants to stay back till the guests leave.